abused.
Hey, I'm not even plugged into my microphone, guys. Dear me. Totally disorganized. The court feed has just come on, so I'd got this live stream set for 3:30 my time or 10:30 Eastern to account for the 10 a.m. start and the half-hour delay in the live stream. And the court feed just popped on and then promptly oh look, it's gone back to no camera. So maybe I went live prematurely. I do think it's going to be about 15 minutes before it starts. So good morning, everyone over on this channel. I'll go back into silence mode because I'm over on Michelle Walks, listening to the testimony from a forensic psychologist who is currently testifying on behalf of Sarah Boone. It's the defense case. So anyhow, I will go back into silence and we'll await the start of day 8. Day 8, can you believe it? I do think that I don't know if the microphone is actually working or not. Hold on. That's better. There, that's better. It took me a little bit by surprise when the court feed came on. So I haven't actually set my microphone up. I think we're all right now. Good morning from Australia. Yeah, justice for this sweet boy. So yeah, I'm going to go back into silence. I think the last couple of witnesses for the state, I think the landfill stuff, it's a little bit redundant now. I kind of know what they're doing with it, but it is a little bit redundant. So hopefully there's going to be, hopefully we're towards the end of the state's case. And then we're basically going to find out what the defense has to say. Whether they're going to call any witnesses. They may not. They don't have to. They don't have to. I suspect they will, but they don't have to. Anyhow, I'm going to mute out here and go back over to Sarah, and I shall be back over here once court starts. Yeah, court's due to start here any minute. I am running 2 channels, yes. So I'm silent over here because there's testimony going on over there on Michelle Walks in the Sarah Boone case. And it's very interesting testimony from a forensic psychologist who is talking all about Sarah Boone and narcissistic personality disorder and adjustment disorder and substance abuse disorder. It's a whole litany of disorders over there. And yeah, the court feed's on here, so we will be starting here any moment as long as Judge Tammy is on time. And we've learnt in this case that Judge Tammy often isn't on time. But yeah, going over to listen to the Cluster F Booney Loon. Oh yeah, oh yeah. But this is the defence's case, and this witness is a really good speaker, but he's not necessarily doing her any favors. So I'm hopping on over there to listen, because I mute that stream over there, like for me, not for the viewers, when I'm talking over here, so you don't get to hear another trial that you're not interested in. So all right, I'm going back over there. We should be up and running any minute now, though, over here. Court hasn't started yet. Judge Tammy is now 5 minutes late, which is considered on time for her. So if you're just coming in, you've not missed anything. We're not on a break yet because we've not started over here. But I'm silent because I'm over on Michelle Walks listening to a psychologist who is working for the defense, but the testimony he's given is not that great for Sarah Boone, I have to say. But anyhow, I am sure that Judge Tammy is going to be along, sometime today. So sit tight. While you're waiting, you can hop on over to Michelle Walks and listen to the Sarah Boone testimony. There's been a lot of objections this morning, a lot of sidebars, but it's all good fun. So meeting out here again for a little while.
County Superior Court is now in session. The Honorable Judge Tammy Stokes presiding. Please be seated and come to order.
Here we go.
All right, good morning, everyone. Let me get myself set up here. And while I'm doing that, would you please bring out Ms. Simon? All right. So one more plug in and I will be ready to go. All right. And with that, we're on the record for SPCR 220336 J6, the state of Georgia versus Leilani Marie Simon. Let the record reflect that Ms. Simon is present with her counsel, Greg Hilliard and Robert Purse. The state is represented by AUSA Tim Dean, ADA Jenny Parker, and Detective Livens as well. So in getting started this morning, is there anything that we need to take up before we bring in the jury?
Only the issue of scheduling, Your Honor. I'm not sure whether we've talked about how things have shaken out for today yet. We have two analysts from Quantico who are going to testify this morning. I don't think it'll take all that long. And then our next doctor witness is not going to be here till 1 o'clock. So unfortunately, what we're going to have to ask to do is take these witnesses and then potentially have like a pretty early and fairly long lunch break. That's just kind of how feel like we've been pretty good with getting witnesses in and not having to do a whole lot of this.
I know you've
That's
been
where we
great,
are.
great at that, and I've said from the beginning, you know, the trial is gonna run as the trial runs, and so that means we go with the flow. So, Mr. Hilliard, anything on that from the defense?
No, Judge, Mr. Dean told me that, and I understand how it is scheduling with Dr. Dare, so. Hold on, I do have to do one thing first, Judge. Let me put on my microphone and let me
Yes.
turn it on. And can you hear me? Okay, good.
All right, very good.
Mr. Dean told me that, and I understand. And I've had to deal with Dr. Darisaw in the past, so I know getting her schedule because she testifies often is hard. So I'm fine with doing these two witnesses, breaking, and doing Dr. Darisaw. That's fine by us.
Okay, let's move on then with the two witnesses that state has. I'm gonna ask you to bring in the jury.
Juror Henry. Clear, Your Honor.
Thank you, Smith. And ladies and gentlemen, welcome back. Please have a seat. Good morning. So we're going to launch right into testimony this morning. We are probably going to have an earlier than usual lunch and probably a little bit longer period of time, but that's just a matter of witness scheduling, and that happens often in a trial. So just to give you that heads up, but now the question, have you all been able to comply with the court's instructions? Have you avoided conversations and discussions about this case?
Yes, Your Honor.
Have any of you been exposed to TV stories, internet stories, any media in any shape or form?
No, Your Honor.
Okay, thank you very much. The state may call its next witness.
Sherry Fentress.
The evidence you submit to the court and jury in the trial decision should be the truth, the whole truth, and nothing but the truth, so help you God.
Good morning. Mr. Dean.
Morning.
Good morning.
You're here because you conducted some DNA analysis in this case, is that right?
Yes, that's correct.
Could you please introduce yourself to the jury, spelling your first and last name?
Yes, my name is Sherry Fentress. The first name is spelled Sherri. Last name spelled Fentress.
What is your profession and where do you work?
I'm a biologist forensic examiner for the FBI Laboratory DNA Casework Unit in Quantico, Virginia.
And how long have you worked there doing that type of work?
I've worked there for about 14 years.
What does your work consist of there? What kind of matters do you work on?
As a biologist forensic examiner, I perform primarily work on missing persons and unidentified remains cases, in addition to some other criminal casework. As an examiner, I will receive case information and determine what pieces of evidence need to be tested based on that information. I'll determine what the best course of testing is for those items, And then I am the one who will coordinate the movement of the evidence through the laboratory, directing the work of biologists along the way and making key decisions at certain points in the testing.
I'd like to ask you some questions about your education, training, and experience that allows you to perform this type of work, okay? Can you tell us a little bit about your education first?
Yes, I received a Bachelor of Science in Animal Science with a concentration in Agriculture Biotechnology and minors in Biology and Chemistry from the University of Delaware. And then I went on to receive my Master of Science in Criminal Justice, specializing in forensic science from Michigan State University.
What about training?
In order to be an examiner, I go through a training that's about 2.5 years. It consists of practical laboratory exercises and oral boards, as well as moot courts, in order to make sure that not only do I understand the fundamentals behind what I'm testing, but also that I can express it in a clear manner for you in court.
And experience?
My experience, in addition to working for the FBI laboratory, spans about 10 years prior to that. I worked for the Armed Forces DNA Identification Laboratory as a graduate intern. I worked for a private laboratory also, and then for the 5.5 years prior to working for the FBI laboratory, I worked for the state of Delaware.
Have you testified as an expert witness on matters concerning DNA in courts before?
Yes, I have. I've testified in both federal and state courts.
And have you been admitted as an expert in each of those instances?
Yes, I have.
Now, at this time, I would offer Dr. Fletcher's as an expert in the area of DNA analysis, forensic biology. No objection, Your Honor.
All right, she is so entered.
Okay, and Your Honor, just to clarify, it's not Dr. Fentress. I have a master's, but not a PhD.
Pardon me, thank you for the correction. I just figured with all of that.
Thank you.
Okay. Were you asked to conduct something called a kinship analysis or kinship comparison in this case that we're here for today?
Yes, and a kinship analysis is just an evaluation of relatedness between individuals.
And what did you receive to conduct the kinship analysis in this case?
In this case, I received a number of bone and tissue specimens. We would term those questioned items because we do not know where they came from or the individual that they came from. And I received reference samples from 3 individuals, Billy Joel Howell, Henry Moss Jr., and Leilani Simon, to compare to these unidentified remains.
And what is it that you're trying to figure out in a kinship analysis? As simply as you can put it.
In a kinship analysis, I'm just testing to see whether the relationship that's proposed could be supported by the comparison of the profiles that I obtain from the evidence. So in this case, I want to see if the unidentified remains could be the child of Leilani Simon and Henry Moss Jr.
And how do you go about conducting a kinship analysis? What do you do?
So in order to conduct that, we first need to test the items to recover DNA from them. And that involves a sequence of steps in the laboratory. We first take a small cutting or sampling from each of the items. We then will isolate the DNA. And then in the next step, we determine about how much DNA we were able to recover in that first step. And based on that, we can optimize the remaining steps where we do amplification, which is where you make billions of copies of targeted regions of the DNA. And then the final step where we determine exactly what is the profile at each of those locations. And just to clarify a little further, for the DNA casework unit, we look at 21 different locations that are expected to be different between individuals with the exception of identical twins, in addition to 3 locations that will provide information as to whether the individual who provided the DNA is male or female.
Now, was the technique you used in this case, is that something that can be tested?
Yes, it's something that can be tested for validity, yes.
And has it been subject to peer review and publication?
Yes, it has.
Are there standards controlling the technique?
Yes, there are standards called the quality assurance standards that are issued by the FBI that define everything from what personnel qualifications are required down to handling the evidence and what types of laboratory procedures should be performed for each type of evidence.
And has it attracted widespread acceptance within the relevant scientific community?
Yes, it has.
Okay. When you conduct a kinship comparison or kinship analysis, how do you phrase your ultimate results or conclusions? What does it sound like?
So when I conduct that kinship comparison, like I said, I'm comparing the profiles against each other. So what I would say is that based on the comparison of the DNA profiles, the results are however many times more likely if the individuals are related as stated than if they are not related.
And I'd like to draw your attention specifically to two items that you tested in this case. Do you see in front of you a document marked as States Exhibit 79?
Yes, I did.
And how many pages is that document?
It's 2 pages.
Now, these are bones that had already been examined by the forensic anthropologist, Dr. Christensen, before they came to you, is that right?
Yes, that is correct.
Okay. And we've heard testimony from her that she'd already identified these bones as human bones. What are the images that you're looking at? What are those from and what do they show?
The images that I'm looking at are 2 of the bones that I tested. I can tell that they are, am I allowed to hold up the?
Well, let me get it
Okay.
into evidence first.
I can tell that they are bones that I tested because they are the laboratory number 2022-02600, the item numbers 29-1 and 30-1, and I recognize these pictures from my case notes.
Did they fairly and accurately depict these bones as they appear to you in the lab when you were working with them?
Yes, that is correct.
Your Honor, I would introduce this as States Exhibit 79.
No objection, John.
Sometimes admitted without objection.
Now, can you, I don't want to put this on the screen, but can you hold that up and walk the jury through what it is that you're looking at there?
Yes, so if you can see, this is the item 29-1 bone. If you see there's a square taken out of the center there, that was the cutting that we took in order to do the processing. And then on the next page, this is a little harder to see, but it's item 30-1, and it is a small bone right there in the center. Because of the size of the bone, we had to use the entire bone for this sample. So there's no specific cut area that you will see.
There's not an additional photo showing like a piece of it cut off because you had to use the whole thing.
That's correct.
You were able to take these 2 bones and develop a DNA profile of the person from whom they originated.
That is correct, yes.
And you were able to compare that to DNA samples from Henry Bubba Moss Jr. and from the defendant, Leilani Simon.
Yes, that is correct.
And you were able to come up with a conclusion as to how likely it is, or the likelihood ratio for whether the person from whom these bones came is those two people's child, right?
Yes, I was able to develop a likelihood ratio explaining how much support there is for the relationship, yes.
And what was your conclusion in that regard?
Your Honor, may I refer to my report to state the conclusion?
Yes, ma'am.
Starting with the item 29-1 bone, based on the STR typing results and the comparison of item 29-1 to Moss Jr. and L. Simon, the combined kinship index is approximately 4.1 quintillion. Therefore, the DNA profile obtained from item 29-1 is approximately 4.1 quintillion times more likely if item 29-1 is from the son of Moss Jr. and L. Simon than if item 29-1 is from someone unrelated to these individuals. And these results provide strong evidence that item 29-1 originated from Quinton Simon.
as to the next bone in Exhibit 79.
And for this one, based on the STR typing results, the DNA profile obtained from item 30-1 is approximately 12 quintillion times more likely if item 30-1 is from the son of Moss Jr. and L. Simon than if item 30-1 is from someone unrelated to these individuals. And these results also provide strong evidence that item 30-1 originated from Quinton Simon.
One moment, please, Your Honor. No further questions.
Thank you. Any cross?
I do, Judge. Ms. Finchurst, how are you?
Good morning. I'm doing fine. Thank you.
Okay, I don't get people like you on cross-examination very often, so I'm gonna have a bunch of questions for you that I don't get to ask, okay? So let's start. Kinship analysis is, are you looking at alleles or genes or DNA? I mean, I don't understand the difference between the two.
Sure. So alleles, genes, and DNA are all related to DNA. When I say that I'm looking at different locations and I'm looking at the profile at those different locations, that would be where I'm referring to alleles. So to take a quick step back, when we look at the nuclear DNA, we're looking at what are called short tandem repeats. And those are short patterns of DNA that are repeated back to back to back. And that number of repeats may differ between individuals at any given location. And it can also differ between locations within an individual. So as I mentioned, we look at 21 of those different locations. What I had yet to say is that we receive half of our DNA from our mom and half from our dad. So at each of those locations, you would expect to see no more than 2 of those numbers. So for example, if at one location I'm a 15-17, it means that I received a 15 from one parent and a 17 from the other. So you're going to expect to see 1 or 2 numbers at each of those locations. Now, when I do my comparisons, where I'm looking at that unidentified profile compared to the potential parents' profiles, what I'm looking for is that pattern. Do I see 1 number from each parent at each of the locations in that questioned or unknown item? And if I see support for that, then I will go on and perform that kinship calculation for the statistic that I mentioned, that 4.1 quintillion or that 12 quintillion.
And the reason why I ask that is this is kind of me nerding out a little bit, but when you're doing the DNA, I mean, DNA is an amazing structure, is it not? Okay. Yeah. But basically what you're doing is looking at, and how many, let's just say on a random piece of DNA from any person, how many different, I guess you would call it, locations are there on that strand of DNA?
So there's a large number of different locations on that strand of DNA. And actually, to clarify further, most of our DNA is actually going to be the same. That's what makes us human. It's a very small percentage. It's less than 1% that will differ between individuals. Again, that's with the exception of identical twins. So we, in our laboratory, target 21 of those locations.
How many locations are there?
I can't remember off the top of my head exactly how many locations there are.
Millions?
Thousands. I don't remember exactly how many.
Right. So, but you target these 21 particular locations and these other 3 locations. So you narrow your analysis down to basically 24 separate locations, right?
This is correct, yes.
Okay. And I'm curious because, again, like I said, this is kind of a weird thing to me. The bones you tested, one was 4 quintillion times more likely to be related, and the same bone tested differently was 12 quintillion times more likely to be related. What accounts for that statistical discrepancy?
So those were 2 different bones that were tested. When we obtain a DNA profile, I would say a common misconception is that if you obtain a DNA profile, you just got DNA and that's all that matters. But really that profile can range anywhere from 1 of those locations all the way up to the entire profile that we're targeting. The fewer locations you have, the lower that number is going to be when you have a calculation. So for the first bone, I was able to get 20 of the 21 locations for a comparison for that kinship statistic. And for the second bone, I was able to get all 21 of the locations. So that's where you get the slight difference in the numbers.
I was just curious. And I'm fascinated too by the actual manner and method of testing. So obviously you would take the bone and I guess what would you do with the bone once you get it?
So once we get it, we want to make sure that the bone is clean on the outside. So we do some washing of the bone. We will then sand the area that we're using, that we're going to cut with what's a Dremel tool, if any of you are familiar with that. And then we will take a cutting, again, with the Dremel tool of that small section that we're going to be testing. We then use something called a freezer mill that freezes the bone, and then it uses a magnet to crush it into a fine powder. And then that powder is what we will then apply the chemicals to in order to isolate the DNA.
And then when you take the DNA and you test that, how do you get your statistical analysis from the testing of the DNA after that?
So once we test the DNA and I've obtained that profile, again, I'll do that visual comparison first. If in that visual comparison, I didn't see evidence of a parental-child relationship, I would say that was an exclusion, meaning those remains could not have come from a child of the two individuals. Because I saw that pattern, I then took those profiles and I uploaded them into a kinship calculation software. And what that software does is it analyzes the proposed relationship, and based on the population frequencies, or how often do you see these different profiles in the population, it provides that statistic for how likely those profiles are if the individuals are related as stated.
And by profiles, and I don't want to put words in your mouth, but my understanding is it'll like show these different genes or genetic markers. How does it display that? Is it like letters, numbers? How does it identify?
So that profile in our case notes will be in the form of a table. So in that table, each of the locations is listed. And for each of the locations where a profile was able to be obtained, you'll see the number. So for example, the first location, D3, you might see that 1517. At another location, maybe FGA is another location, it may say 22, meaning 22 was received from mom and 22 was received from dad. So again, you'll have that table with each location, and next to it, the set of numbers associated with that location. And that comprises the profile for the individual.
And just out of curiosity, you said that when we were going through your bona fides to do this, how old are you again? I'm not trying to pry, but I was just curious. How old are you?
I'm 45.
Okay. And you got your Bachelor of Science from University of Delaware, correct?
Yes, that's correct.
And you got your Master's of Science in Criminal Justice. I didn't write that down, so I don't remember. Which university was that?
That was from Michigan State University.
Okay. How long does a master's normally take?
I would say 2 to 3 years.
Okay, so and I assume the bachelor's was a normal 4-year degree.
That's correct, yes.
And then 2 to 3 years for your master's, correct?
Yes, that's correct.
And then on top of that, you went to extra training at the FBI from about 2.5 years, I think is what you said, 2 to 2.5 years?
Yes, as an examiner, yes.
Okay, and part of that is they trained you how to present this testimony and evidence in court to be explained to normal people like me, correct?
Yes, that's correct.
Okay. And of course, how to do the job itself, right?
Yes.
Okay. And how long have you been an examiner at the FBI?
I've been an examiner at the FBI for 10 years now. Prior to that, I was a biologist.
And how long were you a biologist?
I was a biologist for about 4 years. And to remind you of the difference, biologist does the laboratory processing, and an examiner will coordinate that processing.
And as an examiner, you basically, what you just described is you take the bones, you test the bones, and you translate that into, I guess, the results that you testified to here today, correct?
So as an examiner, I would assign the testing strategy for the bones. I would coordinate the testing. If there's any questions, the biologist will come to me. If there's any questions about how to proceed, there are several steps along the way where I have to make the decision as to how to proceed. And then once data is produced, I analyze that data. I generate the report with the conclusions, and then I'm the one who is able to testify to those conclusions.
Ms. Fenestrous, thank you so much for your testimony. I appreciate it, and it's been so informative to me, okay? Thank you.
And may this witness be excused.
Yes, Your Honor.
All right. Thank you, ma'am.
Thank you.
State me call its next witness. You certainly may.
Yeah, Mr. Annoying was very jovial this morning. Not like
Cynthia
him.
Morris Kukowski.
The evidence you shall give the court and jury in the trial of this issue shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Good morning.
Good morning.
Morning, could you please introduce yourself to the jury, spelling your first and last name?
Sure. My name's Dr. Cynthia Lynn Morris Kukowski. That's Cynthia. Last name is Morris-Kukoski.
And you're here today because you conducted some forensic toxicology analysis in this case.
Yes, I did.
Where do you work?
I work at the FBI laboratory in the chemistry unit.
And what's your official title or position?
I'm a forensic examiner toxicologist for the chemistry unit.
And how long have you been in that position at the FBI lab?
I've been in that position for over 20 years.
And what sort of things do you do there?
As a toxicologist, we work on biological evidence, things as blood, urine, vitreous, vomit, tissues, and sometimes foods and other stains.
I'd like to ask you some questions about your education, training, and experience, okay?
Okay.
Let's start with education. Can you tell us about what education you have that puts you in a position to do the work you do?
Sure. I have a bachelor's of science in pharmacy from the Massachusetts College of Pharmacy. I have a doctor of pharmacy from the Massachusetts College of Pharmacy, a clinical residency in clinical toxicology from Hennepin Regional Poison Center.
And what about training?
At the FBI laboratory, we undertook a 2-year extensive forensic examiner training. It breaks down into both written didactic tests in various subjects, as well as competency tests on various items of evidence in various exams, as well as moot courts.
And in terms of experience, you said you've been working there for how long?
Over 20 years.
Could you give any kind of a ballpark whatsoever about how many cases you've done forensic toxicology casework in?
A gazillion. I couldn't even begin to.
How many zeros is that?
Yes, that's an over exaggeration, but
A lot.
yeah, a lot.
Have you testified as an expert witness in court before?
Yes, I have. I've testified in various military tribunals, as well as grand juries, state and federal cases.
And in those instances, have you been accepted by the court as an expert witness?
Yes, I have.
Your Honor, I would offer Dr. Morris Kukowski as an expert in the area of forensic toxicology. No objection, Your Honor.
The witness is qualified.
I want to ask you some questions about your work in this case, okay? Did you perform some analysis in this case, the Quinton Simon case?
Yes, I have.
Okay. At some point, did your lab receive from the agents in Savannah here a pillow and a pillowcase?
Yes, we did.
And were you asked to look at that to see whether it was suitable for forensic toxicology analysis?
Yes, I was asked to look at it.
And can you tell me what the results of your review of the pillowcase was?
After visually looking at the pillow inside the pillowcase, I deemed it unsuitable for toxicology analysis, meaning either the debris or stain that was on there was too small and just couldn't be analyzed.
Is it the case that you need, if you're trying to do forensic toxicology on stain of some sort, that you need a certain amount to be able to get off the ground with the process?
Yes, I've analyzed various stains over the years, be it urine stains from someone peeing their pants, vomit stains from being over an item after someone's had too much to drink, as well as blood stains that may or may not contain sweat stains. And basically doing this over 20 years and putting samples, putting some solution on various types of clothing or other household items, we look at the amount of volume that it takes for the particular procedure. And then by putting that on objects, I've pretty much gotten to the point where I can tell you that for most items, I need to cut a 2-inch by 2-inch square piece of material with a stain on it.
And your assessment was there just wasn't enough on this pillow or pillowcase for you to do that?
Correct, there was not enough.
Did you also receive something that appeared to you to be brain tissue?
Yes.
How did you know it was brain tissue?
I went down to talk with the forensic anthropologist after I worked with my chemist to check in the clothing and articles from the house, and had asked her what she received in the case. And she had said that she found and had some debris that I might be interested in that was found within the frontal bone. And I've worked with brain specimens over 20 years, as well as other tissues and organs. And it actually has a very unique smell that you cannot miss.
Now, the forensic anthropologist that you were talking to about this, who was that?
That was Dr. Christensen.
Okay. I'd like to approach with what's been admitted into evidence as State's Exhibit 78 and identified as some images from Dr. Christensen's bench notes. And I'd like to see whether you could kind of indicate to the jury here on the third page of State's Exhibit 78, what this bit of brain tissue that you're describing, what it looks like in this picture, where it is in this picture. Can you tell us?
It's this mass right here. And this was received, Dr. Christensen did a hand-to-hand transfer. This was inside a Ziploc bag, which was inside a paper bag. And then I took it up, put it in the refrigerator for secure storage overnight, had my chemist check it in the next day, and physically put eyes on all of the layers that were there with the tissue.
Pardon me. Yeah, just for the record, you've indicated towards the dark mass in the top center of page 3 of that exhibit.
Correct.
Now, did you conduct a drug screen on that piece of brain tissue to see whether you could detect the presence of cocaine or any metabolites of cocaine?
Yes, I did.
What is a metabolite of cocaine?
Metabolite is a substance that forms when the body is breaking down a particular drug. In this case, when cocaine is broken down by the body, it forms 2 metabolites. Ethylene, if you were using or taking cocaine in conjunction with ethanol or alcohol, and another metabolite, ecgonine methyl ester. There is a third metabolite called benzoyl ecgonine, but benzoyl ecgonine doesn't require the liver. If I put cocaine in a glass of water, I could actually form benzoyl ecgonine.
You understand I'm going to have to give the court reporter the spellings of all these things later?
Yes, sir.
I'll take care of it. Okay. You are really smart. So I'd like to just ask you to explain sort of as simply as you can what the process was for conducting that drug screen on the brain tissue for cocaine and cocaine metabolites. What did you do?
First, you actually have, you take the specimen itself, You take a portion of that, you weigh it, and you mix it 1-to-1 with deionized water and homogenate it, meaning you're going to grind it up and mix it together. You then have to weigh a small portion of that, which is 1 gram, and put that into a test tube. After you have that specimen ready, you're also going to take a negative control brain as well as 2 other samples of negative control brain that I'm going to spike at various levels that I actually recorded and know what they are. After I do that, I add a solution to all of the samples. That's called an internal standard. That's there that has drugs with the similar properties of the drugs I'm looking for, but not the drugs themselves. And I do that to make sure that each specimen actually properly extracts through the procedure. If not, and if it doesn't come through, there's something wrong with that particular sample. All of those samples are analyzed using the alkaline drug screen, which uses solid phase extraction, which is a cleanup method that is used to do away with the debris and the biological material and fats and things that we're not interested in. And it concentrates in these individual one-use cartridges, has a filter in there, and it's filtering out all the stuff we don't want, all that debris. And then we can concentrate with a solution all the stuff we do want, dry it down, put that in a vial, and put that on an instrument called a liquid chromatography tandem mass spectrometer.
Now, all right. This technique that you described, evidently as simply as you can. Is it a technique that can be tested?
Yes, solid phase extraction technique has been used for over 20 years. This procedure has been used at the FBI laboratory since 2006. These cartridges have been manufactured since 2005, has been used widely in the forensic toxicology community, as well as in forensics itself. And the instrument is used not only in toxicology in our lab, but other divisions and also outside the laboratory.
All right, so after all that, what was the result or conclusion you reached as to whether this brain tissue contained any cocaine or cocaine metabolites?
I did not detect any.
Okay, so negative?
Not detected.
Okay. One moment, please. No further questions, Your Honor. Yes, Your Honor.
Dr. Kukowski, right?
Morris Dukowski.
Morris Kukowski. Okay. I'm going to jump back a little bit. Forensic toxicology analysis. Do you only test for what you're asked to test for, or do you test for any type of toxicology?
Depends on the request.
Okay. And let's talk about this particular request. Okay. Were you asked to test for any metabolites of controlled substances or specifically cocaine?
No, I was actually specifically asked to look for cocaine and cocaine metabolites, methamphetamine and its metabolite, fentanyl and fentanyl metabolite, as well as oxycodone and oxycodone metabolite.
Okay. And Mr. Dean said that he asked about the cocaine. You said it wasn't detected, correct?
That is correct.
Okay. That seems different than not being present to me. I assume you use your words properly. So you said you didn't detect any cocaine.
Correct. According to our lab policy, we either detect something or not. It's considered either not detected, detective, inconclusive, or identified. That's
Okay.
just our terminology.
And did you have anything that was detected?
In the brain tissue?
In the brain tissue?
No.
Okay. And so did you test for fentanyl?
Yes, it did.
Okay. Methamphetamine?
Yes.
Okay. Percocets?
Oxycodone.
Oxycodone? I guess oxycodone is another name for Percocet, if I'm not mistaken. I don't want to put words in your mouth. You corrected me, so.
Oh, sorry. Percocet actually is a combination medicine of oxycodone and acetaminophen. In this, I was not looking for the acetaminophen part, just the oxycodone.
Okay. So, and you said that, and I'm curious. So when you take the tissue, I didn't understand anything of what you just said. So,
Okay.
So let's assume you're talking to somebody who has a much smaller brain than you. What exactly does the testing usually include?
The testing includes you analyzing the sample with a negative control that has no known drug in it,
Okay.
the sample itself, and various positive controls.
Okay. All right. And with regards to, you'll tag us to the biological tissue, you'll take it and you will
Process it.
process it. What's involved in processing it?
That's that solid phase extraction where you're removing and filtering out all the stuff you're not interested in, and then concentrating the stuff that's left in that cartridge filter to put on the instrument.
Okay. And how big of a sample are we talking when you do this?
It's a 1 gram, 1-to-1 homogenate. So 1 gram containing of 50-50 water and tissue sample.
Okay. So when you say 1 gram, I assume the total weight's 1 gram.
Correct.
Okay. So it's like half water and half tissue.
Correct.
Okay. I just don't understand. So I'm just trying to make sure I'm not misstating it. Okay. And then I guess you'll put that in that big long word thing you were talking about, the mass.
The instrument, yes.
The instrument, let's call it that. Okay.
Yes.
And then what does that do? Does that use some sort of, is it light, gas? I mean, I don't know how that works. So how does the instrument actually work at detecting things?
Okay. The instrument has pumps with fluid. The fluid then gets mixed and put through a column. The column then separates things out based on the chemical properties, and then goes to an instrument called a mass spectrometer that will actually tell you the mass of what drug you're looking for, and then will fragment it and look at the chemical fingerprint of that particular compound.
Okay. And when you say the mass, I guess is it some sort of light deal or some sort of chemical atomic weight deal? I mean, I don't
Yes,
understand.
it's the chemical formula. So you could take the formula of cocaine and add a hydrogen. It will give you the mass of cocaine.
All right. So I guess it's looking for that particular chemical property.
It's looking, yes, for that exact mass and the exact retention time. So as I said, things come out in a column and get detected in order. And each one has their own time that they come out with their own molecular weight and their own fragmentation.
Okay. And that being said, you said that there were certain standards, and I don't understand the standards, so I'm just asking, to either be classified as detected, not detected, or inconclusive.
Or identified, correct.
Or identified.
Yes.
So, and what are those standards? Because I didn't hear that. So, what are those standards and how do they relate to this?
Okay, not detected means you analyze the specimen as you saw fit. You added the internal standard, which is that solution with very similar properties that was detected in your sample, and you did not see the compound of interest. That's not detected.
Okay. And detected.
Detected means you tested it once and you may have seen something, but for some reason you either didn't have enough specimen or something happened that you couldn't repeat the test. Inconclusive means that you tested it, and when you tested that particular chemical and added that internal standard that has similar properties, if that particular compound did not come through and you could not see it, that's considered inconclusive, because if you can't see something that's very similar in your analysis, you can't say that you potentially saw or did not see what you were looking for.
And just to draw conclusions from this. So in this particular case, having the sample that you tested, all you got the result, and I assume it was not a very much, because I'll look at the picture if you have it. Do you have the picture that Mr. Dean showed you? I didn't see. If you would show me, I guess this was the item. Was that the item or was this the item that you showed me?
That
one. Okay. And so that was the item that showed.
So we know, is that particular item marked?
It's states exhibit 78, item number 3 on 78.
Thank you.
So that was the piece that you tested, and
a portion of it.
that portion of it at least. And with regards to that, I think that's all the questions I have, because I think you've explained everything to me so that I understand it, but I'm trying to make sure. You weren't able to test the pillow or pillowcase, correct? You were able to get enough testing material for this, correct?
For what, sorry?
For the item 78 that I just showed you?
Yeah.
The brain tissue?
That's item 29.
It's, I don't know what your item number would be, but.
Oh.
Yes, I think. Hold on. Yes, item 29.
Yes, sir.
Okay. And were you given any other samples to test, or were those the only samples you were given?
No, I was also given a pink washcloth, a shirt, the pillow that we talked about, pants, and a towel.
Okay. Did you perform any testing on those or no?
The pink washcloth was considered unsuitable for analysis. The towel was considered unsuitable for analysis. And I did test stains from the shirt and the pants.
And I'm just curious, when you said not detected, it means it just wasn't detected in that sample, correct?
Correct, in that tested portion.
That's all the questions I got. Thank you so much, doctor.
Just a moment, Doctor. Any redirect?
No, you're on.
All right, and may this witness be excused.
Yes.
Thank you. All right, so that is the last witness that will be called for now. Correct? Okay. So, ladies and gentlemen, it is 5 till 11. So this is going to be an early break. We're going to begin and resume at 1 o'clock. So I'm going to ask that you be back at 12:50. All right. Again, do not discuss the case. Don't let anyone discuss the case with you. Don't watch any news. Don't do any research. You know the drill by now. All right. Have a good break.
Jurors exiting.
Wow, exactly the same things just happened over in Leilani's. How nuts is that? No, in Sarah's. This is Leilani's. Oh, dear God. Dear God. Tammy treats this like a hobby. Yeah. Not quite a 2-hour break. Yeah. 2-hour break. Mason, member for 5 months. Loving coverage. Good stuff. Good stuff. We're all broke. We're all broke. Yeah, line up the Delphi updates. Incoming. Don't you worry. Incoming. Thank you, Sean. $3.99. That's very kind of you.
Thank you, Smith. All right. Anything we need to deal with now? I don't think so either. All right. See you around 1 o'clock, ready to go. We're in recess.
All right, we've got A1 Way Street. Hello, there's Hector. Woohoo. A1 Way Street member for 4 months. And thank you so much. And Be Real member for 7 months. Fantastic. So they don't have another witness till 1. Exactly the same things just happened in Sarah's, that they don't have a witness until 1 either. But this is half-hour delayed. So as Court TV's got on the screen there, they've got a lunch break till 1:30. So that's 1:30 for us. They're back at 1 their time, but it's 1:30 for us and the rest of the world. All right. 1:30 Eastern, obviously. All right, so I am going to do the Delphi update that I've just done over on Michelle Walks. And I'm gonna have to put a banner up though. Hold on a minute. So I can't use that one. I'm gonna have to make another banner. All right. Court is on a break until 1:30 p.m. ET. Okay. All right. No, wrong one. Wrong one. That's the one. Okay. All right. Going to do a Delphi update. Let me just give me a second to get this situated here. All right. So this is a motion. If you were over in Sarah's, you've just heard this, I'm afraid. I don't have a PDF for this as of yet. Hold on. Let's just see. Oh, yes, I do. It's easier to read it off the PDF. It's a little bit blurry when I read it off Reddit. But let me just download this. All right, okay. Okay, so this is our first Delphi update of the day. So the defense has submitted this motion, which is a motion to resubmit Odinism into the trial. So if you remember, way back when, Nick McClelland, prosecutor, said he didn't want Odinism and geofencing or anything like that into the trial, and the judge said, yes, of course, Nick. Anything you say, Nick. Oh, thank you, Dragonfly. It's not easy. It's not easy. Yeah, it's her rules. Yeah, so the judge said, yeah. So she granted the motion in limine to prevent the defense from mentioning Odinism, ritualistic killing, or any of the third-party suspects in the trial. Does the sound keep going in and out? Does it? Does it? Does it for anyone else? Maybe my microphone, because I set it up very quickly when the court went live. Sound all right for everyone else? Oh, yeah, it's going to be denied. Not for you. No, it's fine. All right. Okay. Only for a sec. All right. Okay. May just have been the internet that blipped out for just a second. We should be okay. All right. So yesterday, the witness, one of the CSI guys, he mentioned the sticks that were on the girls' bodies. So with a motion in limine, yes, the information is excluded, but if a state's witness opens the door, so mentions a thing that opens the door, then the court will have the option of overruling the previous order. The same is potentially happening in relation to the sketches, which are also out. But Betsy Blair, who was on the stand yesterday afternoon as an eyewitness, who just confused matters because she didn't see Richard Allen, she opened the door for the sketches. So Judge Gull is going to have to rethink the denial of the sketches because Betsy Blair opened the door by mentioning the sketches. So the same's happened here. So that's where we're at. So motion to admit evidence into Odinism, Norse paganism, ritualistic killing. Comes now the accused Richard Allen by and through counsel moves this court to admit certain evidence that this court thus far has prevented the defence from presenting to the jury pursuant to its September 4th, 2024 order. In support of said motion, the defence states the following. On Tuesday, October 22, 2024, CSI Brian O'Leary testified concerning various aspects of the crime scene. So that was yesterday morning's testimony. During his testimony, CSI O'Leary indicated that the sticks covering the girls was an attempt by the killer to conceal the girls' bodies. On September 18th, 2023, the defence filed its first Franks memorandum in which the defence laid out in painstaking detail the various pieces of evidence that provide support for the theory that the crime scene contains various signatures related to Odinism/Norse paganism. On August 4th, 2024, the defence provides the testimony of Dr. Dawn Perlmutter to the court. Dr. Perlmutter provided her CV and testimony at said hearing. Dr. Perlmutter's experience included, amongst other things, training the FBI and other local, state and federal law enforcement agencies concerning how to identify a ritualistic crime scene, and literally writing the book on ritualistic crime scene identification used by local, state and federal law enforcement. After reviewing the crime scene photographs and other reports and documentation, Dr. Perlmutter's testimony, including her assessment of the sticks on the bodies, F-tree and other aspects of the crime scene, they were textbook signs of a ritualistic murder related to Odinism/Norse paganism, including sticks and blood on the tree to form runes and bind runes. Bind runes are when two or more runes are put together, which then creates a unique message to whoever can read runes. Dr. Perlmutter's belief did not come out of left field as law enforcement began investigating the Odinism/Norse paganism angle as early as 2 days after the girls were found, and law enforcement continued investigating the Odin/Norse paganism angle until the death of law enforcement officer Greg Ferenczi in 2021, who was murdered. He was murdered by an ex-corrections officer. Fancy that. The state of Indiana has provided its explanation of what the sticks represent, concealment of the bodies. And Richard Allen has a Sixth Amendment right to offer the jury his alternative theory, indeed he does, as to the reasons the sticks were aligned and arranged in the manner in which they were arranged. Denial of this opportunity to present the jury all alternative explanations would leave the jury with only one explanation, the explanation provided by the state of Indiana. Additionally, the sticks on the girls appear to be arranged in a pattern/arrangement, or at a minimum, using a person's own eyeballs. Common sense, logic, and reason could cause a reasonable person to believe that the sticks were formed into such pattern/arrangement and weren't being used to conceal the bodies. There was much easier ways to conceal those bodies. Kicking leaves over them would have been easy. Arranging sticks in a very precarious way was not easy. Therefore, it could or would be confusing to a juror who might think that the arrangements of sticks was intentionally placed in a certain arrangement on the bodies, but then those jurors aren't being provided with any explanation for the way the sticks are placed on the bodies in a certain arrangement. Evidence of Norse paganism/Odinism would therefore assist the trier of fact and alleviate confusion for jurors. Additionally, it has been learned at the August 1st, 2024 hearing that the blood found on the F-tree resulted in the state of Indiana, this is hilarious, retaining a blood spatter expert, which did not bother to do at any point before. So it was only in August of 2024 that the state of Indiana employed a blood spatter expert, even though the scene was full of blood. Okay, cool. More than 7 years after the murders, Dr. Perlmutter's testimony would be offered in part to counter the testimony of the state's blood spatter expert, and the accused has a Sixth Amendment right to counter their blood spatter expert's testimony. Being able to provide evidence to the jury that Odinism/Norse paganism is an alternative explanation of the stick arrangement on the girls' bodies, including the testimony of Dr. Perlmutter, would offer the following: a rebuttal to the state of Indiana's explanation of why the sticks appear the way they appear, consistent with the 6th and 14th Amendments of the United States Constitution, a rebuttal as to the state of Indiana's blood spatter expert, an alternative explanation to any confused juror who believes that sticks and blood on the tree weren't used for concealing the bodies, but rather believes the sticks were arranged by a Norse paganist/Odinist as part of a ritual. Defendant files this motion currently, in part for the purposes of ruling in anticipation of the need to contact our witnesses in the event the court reverses the ruling. So what do you think to that? I know. Yeah. The state have opened the door. They are awesome attorneys. They are. They're brilliant. If I ever commit a crime in Indiana, or I'm accused of a crime that I haven't committed, I want Brad Rosie and Andrew Baldwin to represent me. The judge will just ignore it. She'll deny it because she can. Right, I'm going to do a quick shufty on Twitter to see if there is anything. There wasn't anything 10 minutes ago because it's not lunchtime yet in Indiana. So it's going to take a minute for things to come through from people who are in the courtroom. So what I'm going to do is I'm going to take a little break because both channels are on a break at the same time. So what I'm going to do is this channel is going to go silent for the next 50 minutes. And at half past the hour, so half past whatever it is in your local time, so it'll be 5:30 my time, it's going to be 12:30 Eastern and whatever it is in your local time, I'm going to be back and I'm going to talk to both channels. I'm going to talk to both channels and we can talk about the cases. We can do the Delphi update and yeah, it'll be just easier to talk to both channels. And yeah, so go and amuse yourselves for the next 50 minutes. And then whichever channel you land back on, we're going to do Delphi update and we're going to talk about the cases that we're covering here. All right, so I am muting out for actually 48 minutes on this channel. So I'm going to be back in 48 minutes. Don't do anything I wouldn't do in the meantime. All right, I actually got a break today. Can actually get something to eat today instead of just eating donuts and cookies, which is what I've been doing for the entire coverage of these two trials. All right, so I'm going to see you at half past the hour, 48 minutes. So bye for now, guys. Hello. Unlike Judge Tammy, I am not late. I am absolutely on time to the second. All right, so I am talking to both channels. So if you've got me on both channels, if you've been flitting between Leilani Simon and Sarah Boone this morning and you've got me on two channels, then you need to mute one for the next few minutes or else you're going to get this really horrible echo. Echo. So as long as you mute one, you'll be fine. All right, so got a quick Delphi update. It doesn't look like they're out for lunch yet, but Defense Diaries, Bob, has done a very, very quick, like 5-minute. I'm just taking the things off both channels. A quick 5-minute update on Twitter Live. It's called Spaces. So I'm going to play it. I haven't heard this yet because it was like, I thought there's nothing on this because for the first like 45 seconds, there was nothing. There was no sound or anything. So I was just about to like think, well, there's nothing on this. And then he spoke. So I'm going to play this. It's well, about 4.5 minutes, nearly 5 minutes. And I haven't heard this, so I have no idea what he's saying. So this is Bob from Defense Diary speaking. Again, you will need to mute out on one channel because you'll get a horrible echo if you don't. It's as simple as that. So, all right, I'm going to play. I'm going to press play on both channels at the same time. And I'm going to have to remember to mute one, or else I'll get a horrible echo as well.
I figure it's probably a better and more efficient way to give you guys a little information during these brief breaks. So we've had 2 witnesses on the stand this morning. First witness was eyewitness Sarah Carbaugh. If you're familiar with the case, you know that she is one of the witnesses that was not on the trails, but had driven down 300 North, and she is the muddy, bloody witness. She was interesting. She was an interesting witness. She was very combative with Baldwin on cross-examination, which I thought was interesting and a bit unusual. I'm not sure why she was so combative. Her story changed multiple times during the 3 interviews that she gave over the course of 2 years. Initially, Baldwin established that she did not mention the word bloody in her first 2 interviews. Now, in her second interview, she made a claim that approximately an hour to an hour and a half of her interview with law enforcement of the video has vanished. And it was during that time that she used the word bloody. The state had not brought that up during direct, so I thought that that was very unusual. She, as I said, was combative. Baldwin had to refresh her recollection with the transcript of her first interview with respect to her not saying the word bloody initially because she was adamant that she had. He then handed her the transcript, and basically she reviewed it very thoroughly. And she says, it doesn't appear that I used the word bloody, but I know I said it. So she was really dug into the position. And when I'm saying combative, I mean combative. Like, she was coming back at Baldwin pretty hard. And I'll obviously get into the details of what she said. I didn't even bring my notes down. That witness lasted about an hour. So in comparison to our 3 eyewitnesses that we had yesterday, those ranged from about 25 to 35 minutes max for both direct and cross-examination. So this was a very lengthy eyewitness that was up on the stand in terms of comparing to the other 3 eyewitnesses that we had yesterday. It's a really interesting one. I'm going to go in depth tonight during the live with her. I found her to be off-putting personally. I did not think she was a great witness for the state. I thought she was overly combative. There were multiple questions by the jurors, which if you follow our lives, I love. It just shows how in tune they are with this trial, how much attention they're paying. Second witness that came up, and I've got to run back in. We now have the forensic pathologist, Roland Core. He is on the stand currently. He is who performed both autopsies, and we're about an hour into his testimony, and it is, as you can imagine, heartbreaking. We're just getting into Abigail's autopsy, which was the first one conducted. I'm going to leave you with this. It appears that there was only one wound, and it was an incision to the neck ranging. You said the initial wound appeared to be about 2.5 inches, and directionality was left to right. He didn't find any other wounds, no defensive wounds, no bruising. He did, upon questioning by Luttrell, who's doing the direct, state that he saw a very faint mark on her mouth, which he could have considered a very light ligature mark, maybe that it was tape, he opined. He couldn't say definitively. They did not find any evidence on her body of tape or any kind of cloth. But so he did state that, and that was the first that we have heard of that. All right, I'll keep you guys updated. I got to head back in.
Wow. Oh my God. Oh my God. Oh my God. Sarah Carbo. Well, let's deal with the medical examiner first. So, I know we're into testimony, so we should be finding out more at the lunch break. Now, in Sarah Boone, the jury are due to come back in less than half an hour. So you guys on Michelle Walks listening to Sarah Boone might not get the full update, but I'll update you in the next break if the stuff that comes out in the next few minutes that you miss. But Michelle After Dark, we've got longer because of that half-hour delay in the live stream. So let's deal with the medical examiner first. So I know we're into his testimony. Just one wound. So presumably for both girls, just one wound. So Andrew Baldwin, in opening statements for the defence, said that 2 separate weapons were used. A serrated edge for one victim and a non-serrated edge for the next victim. So we don't know whether it was Abby or Libby who got the serrated and non-serrated. But this is the witness that is going to confirm what Andrew Baldwin said. Now, I don't believe he would have said that in opening statements if there's no evidence of it. Why would he? Why on earth would he make himself sound like a liar? So there's got to be a witness that will testify to that. And the medical examiner who performed both autopsies will be that person. All right. So there's things that, you know, experts in pathology and forensic pathology can look for to tell what type of blade a slash or a stab was caused by. You know, they can give you the angle, they can give you a load of stuff, right? So they'll be able to tell that if there's evidence of a serrated blade being used, it's like the wound will look different. So I'm guessing that that's going to come out today. Now, he did say, I didn't catch whether it was Abby or Libby. He said there was something slight around her mouth that may have been indicative of a ligature or a gag. But there's no, he can't confirm that. Like, there's no evidence. It's just suggestive of. Now, if the girls were kidnapped and they were held somewhere for any length of time, there is the possibility that they were gagged to stop them screaming, to stop them making noise. So that would make sense. It could also make sense that a lone wolf would immediately, the first thing they did would gag them and then take them across the creek and then slit their throats there and then in the middle of the day. And maybe that's why no one heard anything, because the killer was very quick to get them gagged. Always possible. So that's very intriguing, but we've got no real evidence to back that up. Has either murder weapon been found? No, not that we know of. No, not that we know of. Now, in one of Richard Allen's many psychotic confessions, he said he used a box cutter. Now, a box cutter, my understanding of a box cutter is that the blades are very short. They're very sharp, but they're very short. Could that cause a life-ending wound? Yeah, technically. But they're not serrated, are they? I've never seen a serrated box cutter. Right. We call them Stanley knives here in the UK. I suppose there's different varieties of box cutters, but So no, the murder weapons haven't been found as far as we know. And I'm very sure if the state had evidence from Richard Allen's house that there was a weapon that had traces of the victim's DNA on it, we would have heard about it. We would have heard about it, because that would be game over for me. If they found evidence, of Abby and Libby's DNA on anything pertaining to Richard Allen, whether it was in his vehicle, whether it was in his house, that would be game over. That would be very, very, let's put it this way, it'd be very, very strong evidence. It would be really difficult for the jury to look past that. Let's just put it that way. All right, let's move on to Sarah Carbo, because it sounds like her testimony has ended. So very combative to Andrew Baldwin. That absolutely plays into the defense. This is a very thoughtful jury. They've been asking some really good questions. So we just have a little glimpse into their mind that they are really taking everything in, and they're analysing everything as best they can as each witness, comes and goes. So a witness that's very combative towards the defence, whose story's changed several times, that's going to be a red flag for the jury. So that's certainly not good for the state. Even if Andrew Baldwin couldn't get very much out of her because she was so combative, it's still not good for the state, because the question is, why is she combative? Why is her story changed? And isn't it just ironic? It's yet another interview that was lost because she swears down that she said the man was bloody. She swears down that she said the man was bloody, even though in her written statement, she never mentions bloody. She said he was wearing a tan coat and he was muddy. And then when she had a follow-up interview and she said the man was bloody, oh, look, that interview has been lost. Well, all right, if that interview's been lost, how did Tony Liggett know? Because it was Tony Liggett that wrote the probable cause affidavit. How did Tony Liggett know that she'd said that the man was bloody if it's not written down anywhere? If that it was a verbal interview that was lost, how does he know that she said that? I mean, he might have done the interview and he might remember. He might have remembered. That's fair enough. So it seems to be that whenever there's something that is not conducive to the state's theory, oh, that got lost. So we've got Richard Allen's first interview when he came forward in February of 2017, and he said, he said he got interviewed by Dan Dullard, conservation officer, and he'd said that he was there between 1:30 and 3:30, and Dan Dullard can't find his recording. He swears down that he recorded them all, but he can't find Richard Allen's. And then we've got all of those interviews were lost when the tech had a problem in Delphi PD in the first week. And then there was a whole bunch more that were lost. Do you remember this? Isn't it strange that it's interviews involving people like Brad Holder? They've all been lost. So what you've got is just a short written summary of that interview. It might be like a few paragraphs, but you've not got the whole interview. How convenient is it? How convenient is it? So I think, just my personal opinion, I think Sarah Carbo is a friend of law enforcement. I think she has been not necessarily told what to say, but she's working on their behalf. So I don't think she is an objective witness. Unbelievable it is. Absolutely unbelievable. Unbelievable. Absolutely crazy. So that's so interesting. So I can't wait for the close of play when, you know, the YouTubers who've been in the courtroom go live. I mean, I've all but given up with the mainstream media. I mean, they're great for these, you know, short updates on Twitter. You know, there's people from Fox 59, there's people from Wish TV, there's people from WTHR that are in the courtroom, and they give these short updates throughout the day. They're useful, but I've all but given up with anything that they write in longer pieces, or they're in, you know, pieces to camera, because they're just basically, there's no depth. Let's put it that way. There's no depth. We don't get very much information. So we've got Defence Diaries, who are in there daily, either Bob or Ali. We've got Andrea Burkhart. We've got Lawyer Lee. They're all in daily. So those are the people that I've been relying on for detailed information. We shouldn't be having to do this, though. We shouldn't be having to do this. I wanna listen to that testimony myself. I want to make my judgment about it. So, but we can't. But we can't. We absolutely can't. All right, I'm going to do a search now to see whether there's anything else that's come out here. Oh, we got Jennifer Coffendaffer. What's she saying? All right. Look at the stark contrast between Richard Allen's writing style when he requested an attorney versus when he said he wanted to confess. He spoke to Ellie without a lawyer and hadn't even thought about getting an attorney until he wrote this letter. Is that what a guilty person does? Not in my experience. Allen was incarcerated in solitary confinement in a maximum security prison after leading a middle-class life as a CVS clerk in a small town in Indiana. Anyone could go nuts under these conditions, did Richard? I think so. Anybody would go nuts. I want to hear these confessions. Exactly. There may be issues with the bullet from my lens as a firearms expert. Oh, she's a firearms expert as well. Okay. Let's see the evidence, prosecution. The witness accounts are a hot mess. None of them have a similar story. I know. So this one is the... So this came out yesterday. So this isn't the actual confession. This is the media's recreation of it. So this isn't exactly Richard Allen's handwriting. This is a journalist who's copying Richard Allen's handwriting. I think they've traced it. I think that's what they've done. And then this is the letter that he wrote to the warden when he had just been incarcerated and needed a public defender. So very different handwriting, but I don't know if that means anything at all. I don't know. All right. All right. Testimony from Sarah Carbo raises the issues about all the missing video evidence. Sarah mentioned that part of her videotape testimony where she allegedly mentioned blood was lost. Isn't it just ironic? It's the bit that mentions blood because the DVR was recorded over. This detail is crucial. Yeah. Okay. Absolute nonsense. Absolute nonsense. If people are just hearing about this now, like those of us who've been paying attention have known that there was a problem with her testimony for well over a year now, because it was in Frank's one. Yeah, no, there are two different knives used. One was serrated, one was not. So if Richard Allen did say he used a box cutter, would not be the one used to kill the girls. Anything else? What are we doing here? I don't think there's any of the news crews come out yet. But it's all like people chatting. All right. For Michelle After Dark, the court feed is back. So we're going to be going live there any minute. So I'm going to take my banner off here. All right. So for me, not Michelle After Dark. Did I say Michelle? I don't even know what channel I'm talking to here. For Michelle Walks, the court feed is back. And the jury are going to come back very shortly. Yes, you just missed a Delphi update. You want to rewind about 20 minutes. Carolina Country Chick. Because there's a very, very interesting update from the first session of this morning. Very interesting. So that's what we've discussed. But for those on Michelle After Dark, I'm going to stay and chat with you a little while longer. Let's do Delphi. No, I don't think they're out from lunch yet. Oh, Barbara McDonald's been on Nancy Grace. Delphi murders trial. Would the disturbance of the leaves suggest Abby and Libby went down that side and were forced to wade across the creek, leading to their bodies being found on the other side? Nancy Grace and Newsy Barbara investigate. Of course they do. All right. So, I don't know. Doesn't look like. So it's going to be nearly one in Delphi. So the medical examiner has been, lengthy. They might be a little bit late out for lunch. Yeah, I agree, True Crime Snoopy. I think the last witness was tampered with. Yeah, Sarah Carbo, yeah. I think she's got friends. I think she's got friends that she is maybe protecting, or, law enforcement that she wants to support. She's back in the blue, and many times I will absolutely agree when the cops do a good job. It's the best and worst job in the world. We do need our police. But when they do a bad job, then you've got to call them out, and you've got to call them out in the harshest of terms, because it's people's life and liberty at stake, and, the justice at stake for the victims and their families. It's no, you can't have it. You can't have a corrupt system, or at best absolutely incompetent system. Whichever it is, whether it's incompetence, whether it's corruption, whether it's a combination, I think we're seeing it all in the Delphi case. And that is absolutely tragic. Absolutely tragic for justice. And if Richard Allen is wrongly convicted, that's not justice for Abby and Libby. Free Richard Allen, yeah, free Richard Allen. I think it's corruption. I think there's a big, massive level of incompetence, but there's also that side of corruption that's being fed. It's being fed as a sauce throughout the whole trial. Free Richard Allen. We need to get that hashtag trending. Free Richard Allen. How can girls sleep at night? Well, she thinks she's right. That's how she sleeps. She thinks she's right. Simple as that. She thinks she's right. So what can you do to, you know, to somebody like that? What can you do? I'll get rid of that. All right, so for those on Michelle Walks, Judge Kranick has sat down, so I'm going to mute my mic. And looks like he's going to resume. Yeah, free Richard Allen, absolutely. Looks like he's going to resume the afternoon session. I think we've only got one witness this afternoon in Sarah's case. I think. But have we got our sound on? Yeah, we've got sound. Mr. Kranick needs to unmute himself. All right, so I'm going to mute on Michelle Walks, and I am going to have a chat with Michelle After Dark. So muting now on Michelle Walks. All right, so we are alone now. We are alone now. Goalzilla is ruthless. Goalzilla, I love it. I know. He should have been in a county jail. There was absolutely no reason whatsoever to put Richard Allen in a maximum security facility. No reason at all. Brian Kohlberger's fine in a county jail. And arguably, the Idaho case is bigger than this one. So, yeah. They were heaven sent. They absolutely were. The mayor of Delphi at the time of the killings had no confirmed alibi. He was in absentia during the time of the disappearance killing of Abby and Libby, and he looks familiar to Young Guy Sketch. Is that Shane Evans? Well, somebody murdered them. Somebody murdered them. And doesn't look like it was Richard Allen. That's all we can say. That's all we can say. Anything's possible. Look, anything's possible. It's not justice. It's not justice. It's the very epitome of injustice. They're not out yet. It is only just 1 p.m. their time. I can't wait though. I can't wait. Anyway, what's been going on in Leilani land? Leilani land. What's been going on? Because to be honest, I was muted quite a lot of the time for this morning's session on Leilani's. I know it was to do with the DNA. I know the last witness, they tested some stuff and they didn't find anything. But I was listening to the psychologist on Sarah Boone. Like, to be honest, his testimony was more interesting than the stuff that was going on Leilani's. Have they said yet? Yeah, he did it on the morning break, the mid-morning break. Have they said yet how many more witnesses the state has to go on Leilani's? Because they must be close to resting. Has anybody heard? Listen to the battered spouse expert. He was very good, easy to understand. Yeah, he was a good witness. He was a good witness, except, you know, he was talking in generalizations and he's being paid for his testimony, all right, which is fine. But he's not Sarah Boone's psychologist. That's not what he's testifying as. He's testifying as a subject specialist. So it can only talk in generalizations, and then, you know, given a hypothetical scenario, what his opinion is of that. You weren't in for this morning. Has the mother been? No, apparently not. Blue's mom. Apparently not. Billy Joe. Jennifer Coffindaffer is not a good channel. No, she does. She has a lot of opinions that I don't agree with, but you know, she's always on Court TV and News Nation. I think it's News Nation she's on more. So a lot of people know her. But no, there's a lot of things I disagree with her on. Yeah, she did. She did. That was ridiculous. Yeah, she interviewed Dog the Bounty Hunter on her channel. I don't actually remember that, no. Maybe it's too hard, maybe it's too raw for her. She's a lady who made tea and coffee every night. Yeah, I mean, look, you know, she's got a lot of Twitter followers, and I don't exactly know. Oh, excuse me. Oh, I'm tired. I don't know how many YouTube subscribers she's got. I did watch the Dog the Bounty Hunter interview, I have to say. Is Scooby-Doo still working on the Sebastian Rogers case? I haven't looked. I did a video about the absolute nonsense that's going on Sunday, and I haven't looked since. I just can't with the absolute nonsense that's going on. It's insane. Like, everyone's suing everyone else, and it's just crazy. I can't. That case has just become. If you thought the Summer Wells case was bad for it being a circus, this is beyond anybody's wildest dreams. This is just absolutely insane. Insane. And the only person who suffers is Sebastian. Honestly. It was very cringy. It really was very cringy. Very cringy. I don't know what they're doing over on Sarah's.
Defense is seeking to utilize for the purposes of jury instructions. The court throughout the trial has been redlining the jury instructions that were provided initially by the state at the end of the evidence and testimony presentation.
I'm going to go and have a listen over on Sarah's. The judge is talking. I'm not too sure what he's going on about. So I'm going to mute here so that we don't get that cross-contamination of trials. I'll be back shortly, though. I'll be back before court starts here. And if there is a Delphi update in the meantime, I'll be back. All right. So I just want to listen to what the judge has just said. All right, so what's going on over there is the defense have a witness lined up. I think it might be their last witness lined up, and they are late. So there's an issue. Having a smoke with Tommy.
Defense, do you recognize our jury?
Having a smoke with Tommy. Oh dear.
To left second row, his hand's already up. He knows what's coming. If you can, just raise those hands, confirm you comply to the court's.
Oh, he says all the same things to the jury every time. All right, I'm going to have a look, see if there's a Delphi update. Someone are chatting about his confession. That's no, it's still not out yet. Huh. Okay. All right, so we've got 15 minutes before the jury's back here. Do you want to watch a video? Let's watch a video. Just a short one. Let's do... Not Sarah Boone. Just a short one. Let's do... I can't decide. Somebody decide for me. Let's do Randy Leech, because I think a few people will know Randy Leech's case. So let's do that one. It's only 14 minutes. And by the time this is finished, then court should be back here. So enjoy. If you don't want to watch this, then hop on over to Sarah's. Oh, the witness has just arrived. The witness has just arrived. So if you don't want to watch a short video here while you're waiting, you can hop on over to Michelle Walks, and the witness is just about to give evidence. All right. Hello and welcome to episode 22 of Cold Case Christmas. In this episode, we're going to explore a strange disappearance. An 18-year-old young man went to a graduation party in rural Kansas, and sadly, he never came home. On April 16th, 1988, Harold and Alberta Leech reported the disappearance of their only son. And since then, the search has been on for Randy Leech. This is the story of the young man who went to a party and was never seen again. In 1988, Randy Leech was a senior at Linwood High School. He was a good student. He got A's and B's. He was athletic, and he was a well-liked student at his school. He was the only child of his parents, Harold and Alberta. He weighed only 4 pounds when he was born. He was a survivor. He had to be. But he grew up into a handsome, clever, and compassionate young man. He loved spending his time with family and friends. He had a bunch of animals. They lived on a 10-acre farm. He had dogs, he had chickens. He had a pig at one point called Pork Chop. And on April 15th, 1988, he went to a party doing nothing different than any normal teenager would do. But it changed the life of his parents, his family, and the wider community forever. So what happened? He left his home about 6:45 p.m. on April 15th, and he was going to a high school pre-graduation party in West Bonner Springs in Kansas. He said goodbye to his parents, and Alberta recalls that he seemed happy. He was in a good mood. His dad had just bought him a new lawn tractor the day before, and Randy liked doing work on the farm, so he was pleased about that. He was driving his mother's grey 1985 Dodge 600 sedan. So after leaving home, Randy headed to his cousin's house about 7 p.m. And then Randy and a friend drove to DeSoto to visit a body shop. And this was around 8:30. Where his red 1966 Ford Mustang, which was to be Randy's graduation gift, was situated. Around 9:30 p.m, Randy stopped at Stout's convenience store to purchase some items. 2 candy bars, 2 bottles of soda, and $3 worth of gas, so just enough to, get him around that night. It's not clear if he was alone or not. However, he bought 2 candy bars and 2 bottles of soda, so 2 of each item. So the fact that he bought 2 kind of indicates that there's someone in the car with him. Maybe the same friend that he visited the DeSoto body shop with. We don't know. But around 10 p.m., he was seen at a bonfire party in West Bonner Springs. The party was huge. It had anywhere between 45 and 150 people. Reports were that he didn't appear to be drunk or intoxicated. Others mentioned that as the night went on, he did seem intoxicated, although he'd never been seen with a drink in his hand. So had someone spiked him? It's possible. At around 1:30 a.m., one of Randy's friends, called John, offered to drive Randy home. Now, this potentially indicates that Randy was intoxicated and maybe friends thought he wasn't safe enough to drive. However, it's alleged that Randy couldn't find the keys to his mother's car and he started to look for them. So presumably John was going to drive Randy's mother's car and Randy be the passenger. But while Randy was searching for these keys, John left to take some other partygoers home first. So maybe John was doing the decent thing and making sure that people got home safely. Randy was reportedly last seen at the party between 2:05 and 2:15 a.m. So that would be April the 16th. And he was spotted waiting in line to use the restroom. At 2:30, John returned back to the party to pick up Randy and take him home. But both Randy and the Dodge 600, his mother's car, were gone. So presumably Randy found the keys, realised John was not there, maybe thought John wasn't coming back, so decided to drive himself. Well, that was a huge mistake. At 6 a.m., so this is now April 16th, Alberta, Randy's mother, woke up and realised that Randy had never come home. He had a curfew. He wasn't quite 18. Reports say that he was 18, but he was nearly 18. All right, and he had a curfew, 12:30 a.m. And he usually adhered to it. He was a good lad. Randy's parents searched the house. Alberta called her brother, Randy's uncle, who was an officer with the Lawrence Police Department. He went out to the property where the party had been held to search for Randy, but things had been cleaned up. You know, whoever was left at the party had cleaned up the scene and Randy was nowhere to be seen. So a missing persons report was filed with the Leavenworth County Sheriff's Department. This is something that hopefully at least doesn't happen these days. They were told to wait 24 hours because, you know, he's a big lad, he might come home on his own. So the search didn't officially start until the next day. And it was then, April 17th, that officially the missing persons report was filed and searches began. So the Sheriff's Department tried to find out who was at the party and they managed to interview some people, and that's why we know roughly the timeline of events. The fact that Randy's car, his mother's car, was gone suggests that he'd driven it away sometime after 2:15 when he was last seen. But no one actually saw him leave. And by the time John got back to drive him home, he'd gone. Some people at the party said that a man called Robert had Randy's keys. So did Robert drive the car? Or did Randy get the keys off Robert and drive away on his own? We don't know. Now, over the years, there has been a lot of theories and suggestions about what might have happened to Randy. They go from the slightly wild theories of satanic abuse and that Randy was sacrificed, to foul play, as in someone had abducted Randy and driven him away in his mother's vehicle and murdered him somewhere. There's more down to earth, I think probably more likely scenarios in that Randy was intoxicated and he had an accident. But if that's the case, Where's the car? In any of these cases, where's the car? There's also been a lot of talk about the investigation not being very thorough in those early days. It's always a mistake to wait 24 hours. I know that's something that was always said in the past, and I really hope that sheriff's departments and police departments don't do that anymore. Apparently, it took the sheriff's department 5 weeks to search the property where the party had been held. And when Randy's uncle went there on the morning of the 16th, things had been cleaned up. So if anything untoward had happened at the party, and there's no indication that it had, but if it had, then there was no evidence. There was no evidence to be seen. And if foul play had been involved and Randy hadn't have left that party of his own accord and he was driven away, then any evidence of that has long since gone. Randy's parents hired a private investigator because they felt that the sheriff's department wasn't moving quickly enough. And they set out to publicise their son's disappearance. They put up flyers across Kansas and Colorado, Colorado being a state that Randy enjoyed travelling to. And they conducted their own searches. The sheriff at the time, Terry Campbell, defended the sheriff's department, writing in a letter, "The Attorney General's office has not found flaws in our investigation, nor has any other professional law enforcement agency found flaws or a solution to Randy's disappearance. Mr. Leech must realise that unlike TV cop shows, all mysteries are not solved." And that is true. Cop drama shows give an unrealistic portrayal of how police investigations actually work. But at the same time, I can see just how frustrated his parents must have been if they didn't feel that places were being searched early enough or adequately enough. But searches did go out on waterways, ponds, lakes, to try to see if Randy had run off the road somehow and him and the vehicle had gone into water. In March 1989, a severed foot in a tennis shoe was found on the banks of the Kansas River by someone Randy had known and a friend who'd been at the bonfire party. Authorities scoured the area for other remains but didn't find anything else. But it was concluded that that was not Randy's foot and it wasn't connected to the disappearance. Some people said that Randy might just have left of his own accord and to start a new life. Now, Randy's parents and people who knew him said that that was highly unlikely, that Randy was enjoying his life, looking forward to graduating high school. So there's no evidence that he just ran away. There's no evidence that his parents did anything to him, which was another thing that kind of did the rounds. Lots of rumours, lots of theories, but nothing concrete. The popular dive team, Adventures with Purpose, with now disgraced leader Jared Lysek, did a bunch of searches for Randy in waterways around the area, and they didn't find anything either. There is a Facebook page for Randy called In Search of Randy Leech, and the last entry was in December, just a few days ago. Alberta and Harold celebrated their 60th wedding anniversary on December 16th, 2020. Harold passed away a month later. Sadly, most of their married life was spent searching for their only child. Not a typical marriage, but they loved each other and supported each other as they searched day in, day out for Randy. This picture is not a typical Christmas card, but it shows the love they had for one another and also shows how they carried Randy in their heart. He was never far from them. Please send Alberta your love and prayers as she continues on alone for her search for Randy. Please send her a note of Christmas cheer, as this journey is not an easy one and she needs our support. We love you, Alberta. We will never give up. So Alberta is now on her own, still hoping that one day an answer will come as to what happened to her only child at almost 18 years of age, Randy Leech, who went to a party like many thousands of other teenagers do, and he never came home. I'm not going to play this because it's got music that I think will probably be copyrighted, but there's a short little clip here, just a minute and a half, of Harold Leech, Randy's dad, talking about him, and it's really sad. So I'll leave a link to this in the description box so you can play it yourself. But if you do have any information on the case, you can call either the Leavenworth Sheriff's Department or the Kansas Bureau of Investigation at 1-800-KS-CRIME. So where is Randy? And where did the car go? Hopefully one day Alberta will get an answer as to what happened to Randy Leech. Okay, let me know your thoughts on this unusual case in the comments, and I'll see you tomorrow in the next episode of Cold Case Christmas. Bye, guys. Alrighty, I'm just talking to both channels for a second. We are.
Defense ready to call your next witness. Yes.
Oh, right. Muting out on Michelle Walks. All right. So the defense over there do have another witness. I thought that might be the last witness. All right. So we are due to come back here any moment. Hope you enjoyed the Randy Leech Cold Case Christmas episode from last December. Got a quick Delphi update here. So R&M Productions posted this. It must be, it's about this morning's testimony. So we've not got a lunchtime update yet. But Baldwin asks further questions about Bridge Guy's hair, texture and eyes. You're romanticizing this, Carbo said. You said he had very effeminate eyes, Baldwin said. How could she know that? She drove past him. She's driving by. How can you get a really good look at anybody as they drive by? I did not say that, Carbo said. News 8's Kyla Russell reported that the jury appeared put off by Carbo's reactions. After a cross-examination, State Prosecutor Stacey Diener asked about discrepancies in how Carbo described Bridge Guy's hood and hat. Carbo replied, "It feels like a Tinder profile of hats." With how many hats she's been shown. She continues discussing her June 2017 interview and the portion that has been missing. She said that the part where she had asked to mark the Bridge Guy photo was part of the missing interview block. She mentioned, though, that Bridge Guy's jacket was dark enough to where she wouldn't have seen. This is just insane. So she mentioned that Bridge Guy's jacket was dark enough to where she wouldn't have seen blood on it. So she didn't see blood on his jacket because it was too dark, even though she said it was tan. But his jeans were light enough to show the mud on them. So no blood, but oh no. So yes, no blood, but mud. All right, so the jeans had mud on them. So he probably worked on a farm or something. The jury finished by asking how close she was to Bridge Guy when she saw him at the Mears entrance, to which she said he was within 3 feet of the passenger side. Yeah, but as she drove by, so how fast was she driving? She slowed down to check him out. Why, though? Why? If he's just a guy, why would you slow down to check him out? I mean, maybe she just drives at like 5 miles an hour, like all the time. I just find it a little bit silly. I really do. I really find it very silly. All right, we're going to put the court feedback up. it is now just gone 1 p.m. their time. So, you know, Tammy does love to be fashionably late. So let's not change. Let's not change the habit of a lifetime. All right, we're good to go. House of Cards is tumbling. There shouldn't have been a House of Cards to begin with. This is just insane. Every single witness, there's been something that has been insane. We shouldn't be like this. Yeah. Yeah. There's something with her. Something not right with her. Something not right with her. All right, what's going on? What's going on in Sarah land? Why have we got the whatever that is? What happened? I was muted. I was getting situated. Yeah, but why's the thing gone down? That tune's annoying. Oh, so the doctor is stuck in the security line downstairs. Okay. No, they've already had lunch. The next witness is late. All right, next witness is late. All right, so the next witness is late for Sarah. And Judge Tammy is late for Leilani. Oh, a second lunch, yeah. Yeah. Don't tell Judge Tammy if you're having a second lunch. That'll be another excuse. So, in Delphi, it doesn't appear to be that there's any lunch updates. But it is 1:30 there. So, save that. I will look again, though. I think we've been spoiled a little in Delphi because they've been having early lunches. And because they seem to be having a late lunch, something's going down in Delphi. Something absolutely is going down in Delphi. I think the medical examiner is probably intense because they'll be going through the autopsy findings. That's going to be intense, and it won't be like an appropriate place to stop, will it? You can't leave like halfway through autopsy findings. You can't leave people hanging like that.
Let the record reflect that Ms. Simon is present with her counsel and that the attorneys for the state are present as well.
Oh, from Defense Diary said he has a seat saved every day. Yeah, it's Kathy Allen. Yeah, Kathy Allen arranged it for him.
Thank you.
How many breaks is annoying in 3K?
Right,
well, they do frequent breaks for the jury because they need it. They do need it. You know, they're sitting there. They're literally sitting there all day. And in Leilani's case, we've already had one juror fall asleep. I mean, literally fall asleep. So they always have a morning break, then a lunch, and then an afternoon break, which is fine. And then you've got, if you're a frequent trial watcher, you'll know, you've got all of these other things that happen. So you've got witnesses being late, you've got the jury being late, you've got the judge being late, you've got unavoidable circumstances that happen that mean things are delayed. Always the same, always.
And good afternoon, ladies and gentlemen. Please have a seat. The
But
day is beautiful. I'm glad you had an opportunity.
Leilani's
to,
case specifically has
explain a little
been,
bit of that.
he's
I
been
want to ask, has
ridiculous.
everyone been able
Like
to comply with
beyond.
the court's
Oh,
instructions?
Leilani's back.
No one has spoken with anyone about
Leilani
the case,
is
discussed
back.
the case, or
We've not got any sound on yet, though.
had any
Oh, we have.
done any research?
Oh,
Okay,
we
all
do,
right.
we do.
Madam Parker, Ms. Parker.
All right, so Leilani's back. Right, I'm muting out
Our
on,
next witness, Dr. Darisaw.
Michelle After Dark, so you can listen to the next witness.
The evidence you shall give the court and jury in the trial of this issue should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, good afternoon.
Good afternoon. Doctor, will you tell the jury who you are and where you work, please?
Absolutely. My name is Laura, Lora, Darisaw, Darrisaw. I work for the Georgia Bureau of Investigation, the GBI.
And what do you do at the GBI?
I'm a medical examiner at the GBI.
Will you tell the jury a little bit about your background, your education, your training to be a medical examiner?
Yes, ma'am. I received my Bachelor of Science degree in Electrical Engineering from Marquette University in Milwaukee, Wisconsin. I then received my medical doctorate degree from the Medical College of Wisconsin. Following that, I did 4 years of residency training in pathology at the hospitals of the Medical College of Wisconsin, which trained me to be a general pathologist. And then I did specialty training in pediatric pathology at Baylor College of Medicine in Houston, Texas. And I did, that was a 2-year fellowship. And then I did 1 year of specialty training in forensic pathology, and that was at the GBI through the Medical College of Georgia.
And how long have you been a medical examiner with the GBI?
Since 2004.
So about 20 years.
Yes.
Your Honor, the state would tender Dr. Darisaw as an expert in forensic pathology at this time.
I'm familiar with Dr. Darisaw, there's no objection.
All right, the witness is so qualified.
Thank you, Your Honor.
And actually, I think it was 2002. I'm sorry. Yeah.
Oh,
2002.
22 years.
Yes.
All right. Can you explain to the jury just briefly what the duties of a medical examiner are?
So yeah, primarily the duties of a medical examiner are to examine people who have died in certain circumstances. Generally, the circumstances are that individual has died suddenly and unexpectedly, or has died from unnatural type events such as traumatic events. And the purpose of the role of the medical examiner is to determine the cause and manner of death by doing an autopsy.
Tell them also what an autopsy is, since you mentioned that, please.
So an autopsy is an examination of a person who's died. There's 2 major components to the autopsy. The first component is the external examination. The external examination is very similar to the type of examination that we get when we go to the doctor as live people. We get our height and weight taken. The doctor examines our external body, and that's what the pathologist does. And then in an autopsy, there's also an internal component. And with the internal examination, the body is cut in such a manner as to remove the organs that are in the body cavities to evaluate those organs. And then, like I said, the purpose of doing the external and internal is to determine the cause of death and then a manner of death.
Okay. And when you do an autopsy, what sort of clues are you looking for that can tell you the cause and manner of death? I realize that's a long list, but could you just give us some examples?
Yeah, sure. Briefly, so to even begin an autopsy, we begin with information about the death, the circumstances of the death. And that is the same as when we go to the doctor. We have to tell the doctor why we're there. We have certain symptoms. There's a reason for us to be there. And that's the same with an autopsy. There's always some degree of information of the circumstances of the individual's death that we have to start with. Some of those circumstances are obvious in terms of the cause of death. We know that a person has gotten shot, and so it's kind of obvious that they died of potentially a gunshot wound. And in that instance, the autopsy documents the wounds, provides vital information for court purposes in terms of getting the bullet, for instance. In some instances, a person may die in bed, and we get information from family members about their history, and then that may give us clues as to why they died. So we always have to start with some pieces of information concerning the circumstances of that death.
All right. And is looking at someone's medical history a normal part of performing an autopsy to see what sort of health they were in?
That's correct.
Moving to this specific case involving 20-month-old Quinton Simon, after remains were found in this case, do you recall being consulted by members of the district attorney's office?
Yes, I do.
Okay. And did they come and meet with you and show you photographs of what there was
That's
as far as
correct.
remains?
Yes.
Okay. And then are you aware that those remains went to the FBI?
Yes, ma'am, I am.
To a forensic anthropologist?
Correct.
Okay. After the FBI was done, were the remains sent to your office?
Yes, following the FBI examination of the skeletal remains of this child, I did receive those skeletal remains, and my examination was limited because the FBI was primarily involved as anthropologists, and I'm not an anthropologist. So my involvement in terms of evaluating the skeletal remains was inventorying the bones that we received.
Now, in a situation where the remains are primarily bones, would you be able to perform an autopsy?
No, not in the sense of obviously what I've just described to you as a complete autopsy on an individual who, let's say, is an intact body. So when there's only bones, there's going to be very limited ability to be able to provide enough information to say how a person has died.
And so is it normal in the situation where the remains are basically bones for a forensic anthropologist to be consulted?
Yes.
I would like to talk to you about one specific potential cause of death, and that is what is commonly known as sudden infant death syndrome, or SIDS, as people here call it. What is the medical term for that?
So SIDS is sudden infant death syndrome. That's the acronym for SIDS. And SIDS is actually a definition of a death. It's not anything that one finds in a child. So it's a very strict definition. SIDS is defined as a death in a child who's 1 year old or less, whereby the autopsy doesn't identify any specific cause of death. The autopsy doesn't identify an infectious disease process or trauma. So we call these negative autopsies. And so the autopsy is negative. In addition to that, the definition of SIDS also requires that the investigative information doesn't reveal any suspicious circumstances surrounding the death, or the investigation doesn't reveal any, for instance, in a sleep environment, not an unsafe sleep environment that may cause a child to asphyxiate or suffocate. So it's very strictly defined as being a negative autopsy in a certain age, 1 year old or less, and no suspicious circumstances.
Okay. So a 20-month-old child would be too old to fall under the definition of SIDS.
That's correct.
Give me just 1 moment. Just to go a little bit further regarding the skeletal remains, in this specific case, you were not able to perform any of your duties beyond just doing an inventory of the bones. Is that correct?
That's correct.
And in this case, this wasn't just like remains found lying out somewhere. They had actually been in a landfill and had damage done to the bones.
Correct. Subjected to, environmental damage as a result of being in the landfill.
That's all the questions I have. Thank you.
Good afternoon, Dr. Darasol. How are you?
I'm good. Good afternoon.
So when you received the remains, you weren't able to conduct the normal autopsy, so you couldn't remove any of the organs or tissues or anything like that because you just didn't have them.
Correct.
And if I'm understanding correctly, did you receive any tissue samples or was it just the bones you received?
So in the inventory, everything came to us from the GBI, packaged in bags and multiple bags. Mostly everything was bones. There was small material that could not be definitively identified as organs or skin, but there was some degree of what we would identify as soft tissue.
Okay. So there was some soft tissue then?
Yes.
Okay. And did you perform any testing or anything on that?
I did not know.
Okay. Were you asked to?
No, sir.
Okay. And I was just curious. You said that, of course, in this particular case, when you say you perform an external examination, I assume that means you would look at the body in its normal state in a normal autopsy, correct?
In a normal autopsy, yes.
Right. And that wasn't possible here, right?
That's correct.
Okay. And same thing with the internal examination. Again, you'd see a normal body and you would be able to look, I'm not trying to be graphic, but you split the ribs and the cranium and be able to pull the organs and tissues out as needed, correct?
Yes, we make the routine cuts to gain access to the organs in the body.
And again, you weren't able to do that here.
Correct.
But you also mentioned the other thing a minute ago to Ms. Parker, that you were told the circumstances surrounding the death. I'm curious, were you given any of the circumstances surrounding the death, or were you just given the bones and the tissue sample?
No, I knew the circumstances surrounding the death. Our office was initially informed of the death in October of 2022, that the child had been missing for a period of time, and then the skeletal remains had been, or some of them, the whole body was never recovered. Skeletal remains had been retrieved. I got the bones to look at. Basically, my looking at them was limited, and that was in March of 2023.
Okay. And you mentioned one thing, Ms. Parker, too, was talking about asphyxia or suffocation. We understand 20 months old is a bit old for SIDS, correct?
Correct.
But it's not too old for us to asphyxiate, correct?
It depends on, asphyxia is a very broad term. So asphyxia can be choking on a foreign object, for instance, either a food object or a toy or something like that, or a child can be intentionally suffocated. So asphyxia is broad, and a 20-month-old is not too old for
then let's break it
that
down.
in the broad sense.
Then let's break that down. What's the definition of asphyxia, so we can start there then?
Asphyxia basically means a lack of oxygen for a variety of different reasons. You may not get oxygen because of a certain position you're in, where your nose and mouth are obstructed. You may not be able to get oxygen because something is obstructing your airway. If you choke on a piece of food or something like that. So it's very broad, meaning a lack of oxygen to the brain.
Basically just means a lack of oxygen.
Correct.
It can be because you're choking, it can be because something lodged in your throat, it can be because somebody's strangling you. It can be for any of those reasons, but that's all asphyxia means, correct?
Yes, sir.
Okay. So, and would it be, do you think it would be important for you to know that and you said the other thing you investigate when you're talking to Ms. Parker was about the sleeping area. Would that be something you would need to know for a 20-month-old death?
Not less important in a 20-month-old, because a 20-month-old is able to turn around in bed and move around. They're not as immobile in a sleeping environment as a younger infant.
Okay, well, let's talk about that. At 20 months old, what is a normal 20-month-old's capabilities?
Generally 20 months old, they're able to walk. They're able to roll around in bed and turn from side to side and lift their head. So those are things that they can do.
Okay, so they're ambulatory.
Correct.
They can move and they have their own mind about things, correct?
Correct.
All right. So in this particular case, would it have been relevant to you to know that there was vomit in the playpen where the child was sleeping?
It would have been a piece of information if I had a autopsy to perform on an intact body. The information about the scene itself would be information that we would see, that we would take into account.
Was that information that was passed along to you or no?
I'm not aware of that. I'm not sure.
Okay. All right. And that being said, I think that's all the questions I have. Thank you, Dr. Darrisaw.
Sure.
Any redirect?
No, Your Honor. Thank you. May she be excused?
She certainly may. Thank you, Doctor.
Thank you, Your Honor.
Okay, the state may call its next witness.
Marion Lemons. I think when we left off with our last fact witnesses, before we moved into the expert witnesses, where we were at is that the team had found Quinton, right?
Yes,
And that was what day?
that was on November 18th.
Okay. In the days following November 18th, was the defendant interviewed one final time?
Yes, she was.
Before we get to that, I want to ask you kind of a few miscellaneous questions about some things.
Sure.
Okay. The first is a question about venue, and I may have hit this, but I just want to make sure. Have you reviewed the indictment in this case?
Yes, I have.
Have you seen that it alleges a number of false statements on a number of different dates?
Yes, it does.
Are you aware of all of those statements and where they were made?
Yes.
And were they all made in Chatham County?
Yes, they were.
It's for every false statement charged in the indictment.
Correct, yes.
Okay. There has been an exhibit admitted into evidence as State's Exhibit 62, Circle K footage.
Yes, sir.
And which one of the two trips that night would that footage have been from, the first or the second?
It's her first trip that night.
Now, have you reviewed that footage?
Yes, I have.
And is it fair to say that it includes a bunch of different camera angles?
Yes.
Is there a camera angle in which you can tell exactly what it is that she purchases?
Yes, there is.
And how is it that you can see exactly what it is that she purchases during that trip?
Yeah. So it faces, the camera angle faces the register as well as what is being rung up by the cashier. So you're actually seeing the receipt as it's actively being run up.
I'd like to display for you the portion of State's Exhibit 63 that I think you're talking about. So what I've done here is I've opened up the player that includes all this footage, and it's a whole bunch of camera angles, right?
Yes, it is.
In here, we've picked the register camera that you're talking about and made it full screen, correct?
Yes.
Okay. So sort of an overhead view of the register that she pays at?
Correct.
Okay. Can you tell us where on the screen we can see what it is that she purchases? And you can step down to do that.
Yep. So on the left,
Walk us through it line by line, please.
on the left side of the screen, you see like an itemized list of what's occurring with the register, as well as a quantity. So our targets are right here. We have a natural light 25-ounce can. The quantity's changed to 2 cans. And then we have the cigarillos green, quantity changed to 2. And then, the driver's license scanned, and that's the transaction for Leilani's purchase that night.
Can you tell us where we are in the timestamp here?
So the timestamp that we're paused at right now is 10:29 p.m. on the 4th of October.
And I'm going to hit play from here and we'll just watch the transaction, okay?
Okay.
Is it moving or not? Did you hear what she said?
I believe she asked for rellos or cigarillos.
Stop the playback at 10:31:22. Now, moving on to another miscellaneous item. Do you remember hearing Officer Schenker of the crime scene unit or forensics unit talking about the substance that was found in the back of the Dodge Journey?
Yes, I do.
Did you look back at the file to see whether you could figure anything out about what that was?
So in Schenker's testimony, and it was previously mentioned, we believed it was like a rice cereal. That's also what Miss Leilani told us it was.
All right. And have you prepared an exhibit to address this issue?
Yes.
I'd like to approach with what I've marked as State's Exhibit 94A and 94B.
Okay.
Do you recognize those two items?
Yes, I do.
Can you describe to us what they are?
Sure. 94A is going to be a PowerPoint of what 94B's printout is. It's a collection of photographs with the rice cereal.
Okay. So 94A is the disc, 94B is the printout of that.
Yes.
All right. I would introduce this in as 94A and B.
No objection, Your Honor.
94A are admitted without objection.
Just need a moment here, Your Honor. All right. I think I've got this working right now. And I'm trying hard not to have to ask for a recess here because we're in the home stretch, okay? What is this first slide here show?
So this is a photograph of the back of the Dodge Journey that was taken on 10/6, and it's kind of just displaying the rice cereal in the back of the vehicle.
Appears to be pretty evenly and widely distributed.
Yes, it is everywhere.
Moving to the next slide, what is this that we're going to see here?
This is just a short clip of the interview that we conducted on 10/5, where she's explaining what that is in the back of her vehicle.
Now, just to make sure we're clear here, the date stamp in the top left corner says 10/6. Can you just, I'm not trying to catch you, I just don't want anybody to be confused.
Yeah, it's the 10/5 interview, but it's early in the morning on 10/6, so technically it's the next day.
Almost 5 minutes after midnight.
Yes.
Okay. Pleasure. I just see it. Let me see here. Yeah, I'm sorry. I guess I have it in my fast for a minute. Almost made it through the whole thing.
Almost. All right. 5-10 minute break. We'll see how this goes. All right. So, ladies and gentlemen, no research. Don't discuss the case, and you're going to take a quick break.
Jury's exiting.
clear, Your Honor.
All right, ladies and gentlemen, please have a seat. We'll take a 5-10 minute break and see how it goes. All right, thank you.
Why are we having another break? Why are we having another break? Yes, we've got a Delphi update. We do. We do. All right. This is hilarious. I've got to show you this. Sarah Carbo driving by the Mears parking lot, seeing brand new people she's never mentioned before. STFU, Sarah. That's funny. That's funny. But we got some more. We got some more. All right. So this is Kyla Russell. Okay. So this is from the medical examiner. So this becomes very contradictory. But anyway, the doctor who performed autopsies on Abby and Libby's bodies testified today, Dr. Roland Kaur. The autopsies happened on February 15th, 2017. Kaur explained what wounds each girl had. Abby had one incision on her neck. Libby had multiple. They did not have blatant defensive wounds or overt sexual trauma. The doctor said Abby likely died in about 5 to 10 minutes and Libby likely died in around 5. But I think they would have been unconscious sooner than that. That all could have been impacted by several factors, though. All right, this is the bit that gets contentious. He estimates they died about 41 hours before their autopsy. There was a contentious back and forth between Kaur and the defence, as the doctor had said in his original report that the girls were wounded with a serrated edge. He said today, even though he is not certain, the girls could have been wounded with a box cutter. The defence says he changed his story without telling them. Well, isn't that interesting? That now he's characterising the weapon as a box cutter. Who's he been nobbled by? Now, it does get interesting. 41 hours. 41 hours. So, we don't know when on February 15th the autopsy took place. So, it could have been 7 a.m., it could have been 7 p.m. So you got a whole 12 hours there that needs to be addressed. Could have been even later. So we don't know when that 41 hours, started. And 41 hours is oddly specific. It's oddly specific, given that there was no body temp taken at the scene, which would have been the first clue as to time of death, because all things considered, there's certain environmental factors that do influence it. But generally speaking, the body after death cools down approximately 1.5 degrees. And I can never remember whether that's Celsius or Fahrenheit, and it makes a big difference. But it cools down at 1.5 degrees per hour, approximately. So and to the point where the body then eventually is the same temperature as the outside world, as the environment that it's in. But there are certain factors that change it, and it's not an exact science. So taking a body temp at the scene would have been ideal. However, they did not want to take a body temp at the scene in case there'd been SA, which I guess is understandable. Right? They didn't want to interfere with any evidence, which is understandable. All right, so they died under the state's theory. They died between 2:30 and 3:30 on the afternoon of the 13th. So 41 hours, so 48 hours, let's say 3 p.m., just as a round robin figure. So 3 p.m., so take 48 hours off, or add 48 hours on, so that would be 3 p.m. on the 15th. So 41 hours would be 8 a.m. on the 15th. So if the autopsies were taken and were done at 8 a.m., well, they can't do two autopsies at the same time, and an autopsy takes a couple of hours, so they can't both have died 41 hours ago. Anyhow, but as a round robin figure, if the autopsies were done at 8 a.m. on the 15th, then that would have put the time of death to be 3 p.m. on the 13th. However, we don't know when the autopsies were done on the 15th. But there's more. All right, there's more. Because defense diaries commented. All right, lunch break. Dr. Roland Corey's off the stand. So, yeah, they must have been a little bit delayed because he was on the stand. They wanted to get him done. Broad strokes. Can't give a time of death. Stomach contents were not addressed by either side. So that's another indicator. If you know what they ate for the last meal, you can do an approximate calculation of how that food stuff would break down. So carbs get out of your stomach very quickly. Complex carbs not so quickly, but protein. So if you ate steak, let's say, something really high protein, that's especially if it's meat, it's going to stay around in your stomach for ages, for hours and hours and hours, and putrefy, and it's disgusting. However, as after Dr. Corr was deposed in February of this year, he came up with the idea of what may have caused the serrated abrasion type wounds above the large incised wound on the left side of Libby's neck while he was in his shop. So, he had a thought. So he's just, just he's in his shop. So he's in his workshop, right? So he's just, idly thinking, and he thinks back to the autopsies that he did in 2017, and he thinks, I know what, those wounds on Libby German's neck, well, maybe they weren't serrated, weapon wounds. Maybe it was a box cutter instead. No, I'm sorry. I'm not having this. All right. He opined that they possibly could have been caused by the handle of a box cutter. On cross, Rosie challenged Dr. Corr, stating he had not mentioned anything of the sort while discussing the serrated wounds during the deposition. The doctor also testified that the box cutter theory is pure speculation, as he has no way of knowing what type of short force instrument may have caused those injuries, and opined it could have been an instrument handle or even multiple instruments. They appear to be abrasions. I'll probably do another spaces when I'm done eating. And this is a crude drawing. Don't give up the J job, Bob. So there's the wound, and these are the abrasions, which now the medical examiner is saying could be due to the handle of a box cutter. Well, how does one wound create 1, 2, 3, 4, 5 abrasions from a handle? Yes, it could. All right. That looks like a banana being eaten by 5 worms. So, Cara Weinecke, I never remember how to say her name, commented saying, Well, why are the news saying that they died 41 hours before the autopsy? So he replied to Cara and said, his exact quote, which was prefaced by him stating on the stand that there is no precision to this statement. So the condition of the bodies is consistent with the girls having died 40 to 41 hours before autopsy on the morning of the 15th. That was Luttrell's last question on direct. Rosie asked this question. You don't know when Abby died, do you? Answer, no, I don't. At this deposition, Cora had stated that Abby had died sometime between the last time she was seen and when she was discovered. What do you make to all that BS? What on God's sweet earth is this crap? All right, there's your Delphi update. All right, I'm going back over to Sarah. I've missed a psychologist testifying. This is a long 10 minutes. We've been here before, haven't we? We have been here before. We've been here before. Genius level deduction, yeah. You've got a dead body on your autopsy slab, and they died before anytime between them last being seen and them being found. Yay. Woo. So he's estimated 40 to 41 hours, which will be consistent with the state's theory. And he's also opined that it could be a box cutter, because Richard Allen happens to have mentioned a box cutter during his confessions. Okay. All right. Okay. I believe you. Millions wouldn't. I hope the jury don't. Anyway, I'm going to love you and leave you, because surely Judge Tammy's going to be back anytime soon, and I want to listen to what is left of this psychologist's testimony. So I'll be back, because I'm sure we're going to have another break in like 10 minutes. So I'll be back. All right, just hopping in to answer this question. Videos of the crime scene and a video of Rick Allen playing pool. Want to know my thoughts? Video of the crime scene. I mean, look, the crime scene has been known for many years. It's a clearing near Deer Creek, which is a great place for ritualistic sacrifices to take place because water has significance, as do the clearings in a forest. So, even though this is not a forest, it's woodland. So, appropriate place for a murder of a ritualistic kind to take place, but a strange place for it to take place if you weren't out there to commit a ritualistic murder, because it can be seen by the bridge. If you're standing on the bridge with all the leaves being off the trees in February, you can see right down into that clearing. I mean, probably not well, but still. And video of Rick Allen playing pool. I don't have an opinion on that. It's just a guy playing pool and having fun. There was loads of videos on Kathy Allen's Facebook. So in the first few days after Rick was arrested, people went to Kathy Allen's Facebook and downloaded all the videos off it. So there's a few. There's one of him in his house and Kathy's laughing at something. There's a few people around. It must have been like the holidays or something. And Rick's just sat there and they're all having a good time. So it's a normal night out playing pool. I don't have an opinion on it. So, all right. Just thought I'd hop in. This is a very long 10 minutes. Somebody buy Judge Tammy a clock or a watch or something for her birthday that maybe pings her every 10 minutes. That would be a good idea. All right, muting out. Is it true that Richard changed his appearance after the murders? No. No. He put on some weight, but you've got to think that it's 5.5 years later. More than 5.5 years later.
Of the rice cereal.
All right, we're back. We are back.
Rice cereal.
Moving on to the next slide. What is this image?
This is just a more clear view that Officer Schenker, it's a photograph that he took that night. And again, you're seeing the bar area and those two images of rice cereal, or two containers of rice cereal.
The next slide, what have we done here? Just zoomed in on that one?
Correct.
Okay. And then the final slide, what is this?
This is just a Google image of what we were previously looking at.
Okay. Gerber cereal for baby rice type?
Yes.
Okay. So those two canisters were out there on the tiki bar when police first arrived.
Correct.
And the defendant had told you she took them inside like a month ago.
Yes.
Or more than a month ago, I think.
Yes.
Any reason you know of that those things would be outside?
Objection, Your Honor, calls for speculation.
Sustained.
No further questions on this exhibit. Let's talk about the final interview of the defendant. What was the date again?
Her final interview was on November 21st.
And where was it conducted?
At the FBI office.
By this time, Quinton had been found on November 18th.
Yes, he had.
And at this point, had you taken out warrants, at the time of this November 21 interview, had you taken out warrants for the arrest of the defendant?
Yes, I did.
Now, were y'all bringing her in there in part at least to notify her that the remains had been discovered?
Yes.
And did she know that before she entered the interview room with y'all and was told that?
That the remains were discovered? No.
Did she know before the interview began, though, that she was being arrested?
She assumed so, yes.
Okay. And who did y'all correspond with to get her in that day to the FBI office?
Yep. Her mother, Billy Joe.
And she had been told that the defendant was being arrested that day, right?
I don't believe we told Billy either. I believe they both just assumed that's what was happening that day.
Okay. Where in the FBI office did the interview take place?
It's in the interview room, which is in like the front corridor area.
Now, is it fair to say that this was the first interview in which she was not free to leave?
Yes.
It was in police custody at this point.
Yes, she was.
Given that, did you all, at the outset of the interview, advise her of her Miranda rights?
Yes.
Did you advise her of her right to remain silent?
Yes, there's a form that we read to her, and we provided her with one to read as well.
Did she indicate to you that she understood all those rights?
Yes, she did.
Did she have any questions about any of them?
I don't believe she did, no.
And did you all ask her whether she would waive those rights and agree to speak to you?
Yes.
And did she do that?
Yes, she did.
And was that agreement memorialized on the form that you've discussed?
Yes.
And did she also memorialize her understanding of each of her rights by initialing next to each one of them?
Yes.
I'd like to approach with what I marked as State's Exhibit 80. Do you recognize that document?
Yes, I do.
Can you tell us what it is?
It is the FBI's template format for advice of rights. This is the document that I believe Agent Solomon read to her and explained prior to this interview.
And were you present for that?
Yes, I was.
I would introduce this as State's Exhibit 80. Can I look at it real quick, Judge, just to make sure? I think I've seen it before. Okay. I think I've seen it, but I just want to make sure. No objection, Your Honor.
All right, 80 is admitted.
Now, how long roughly was this interview in its entirety?
Almost 3 hours.
Not going to watch the whole thing.
No.
Okay.
No.
Did it, like some of the other interviews we've heard about, start with this kind of long period of rapport building?
Yes, it did.
And eventually, did you all get into the substance of that?
Yes.
Have we prepared a disc containing a few excerpts from this interview?
Yes.
And do those excerpts capture essentially what her story was for that day?
Yes, it does.
I'd like to approach with what I've marked as State's Exhibit 81. Do you recognize that?
Yes, I do.
Can you tell us what it is?
It is a collection of the November 21st interview. It's a CD.
Series of excerpts?
Yes.
Do you remember how many total?
There's 3.
Okay. And what, could you just kind of describe to us what the 3 excerpts are, if you remember?
Sure.
And if not, we can just run through them.
Yeah. So the first one is going to be kind of the initial conversation that we had about cocaine. In this video, you will see Leilani telling us what cocaine does to her, what she's learned, through some of the counseling that she's had. She'll talk about how she's, experienced delusions, change in emotions while high on cocaine. And we're discussing whether or not that's what happened that night. The second clip is Leilani changing the trash story. She's talking about how there's now 2 bags of trash, and we're discussing whether or not Quinton was in one of those bags of trash. The third clip is us confronting Leilani on how many stories she's told us over the last 2 months and why she told these stories.
Now, what was kind of her core claim on this day about what she remembered about the Azalea trip and the time period leading up to it? What was she saying to you on this day?
The majority of the time, she's saying that she doesn't remember the Azalea trip. She only remembers returning home, specifically going over the railroad tracks right before she gets to her residence. There's also other times where she says specifically that she was throwing away just trash, shrimp pasta, while at Azalea.
Did this claim that she was making to you about just not remembering anything from like 11 something to when she was driving home from Azalea sometime around 1:20 onward in the morning, did this to you conflict with things she had told you before?
Yes, and in the same interview.
Okay. Do the clips on this disc fairly and accurately depict the portions of this interview that you're describing?
Yes, they do.
Other than it being excerpts cut out of a larger file, has it been altered or modified in any way that you know of?
No.
Your Honor, I would introduce this as State's Exhibit 81.
So can we approach on this exhibit real quick? I just
Yes.
wanna Put something on the record.
Sidebar. Wonder whether Lemons is going to be the last witness for the state. Because they've kept bringing her back, haven't they? Like they've told a story through Detective Lemons. Coming back.
Okay, we are back on the record.
No objection, Your Honor.
All right, thank you, Mr. Hilliard. State's Exhibit 81 is admitted without objection.
Before I hit play, where are you in here?
I'm right next to Agent Solomon, to her right, but I am off camera. Occasionally you'll see my arm, but the majority of the time I'm off camera.
This is the first file on the disc. It is 20 minutes and 1 second in length, and I'll play that now.
The only substance I ever consume alcohol, so I know what one drink versus several drinks feels. So how does like the equivalent of that? Like if you had your normal, like what does it feel like to be, triple your normal? Honestly, time goes by quickly. It's almost like you're discombobulated a little bit. If that makes sense. You're so high, you can't lose touch with reality. So how does that usually feel? Like what? It's almost like that tunnel vision, focused on just one thing, down, getting high. Yeah, so like you're not more, you're just focused on that one thing. But when you get that high or whatever, you start, as they said, like, I didn't know the shit that made sense. It's like delusions in your own mind, which you lose touch with reality. Like, are you seeing things, or your brain is just like making up stories? Your brain makes up shit. Yeah, you can end up doing things like you don't even remember getting up and making up eyes. It happens a lot. There's 20 months that I woke up in the past and like there's there cars going somewhere else. I just don't know who. Yeah, and I wasn't terrified. I like him for like doing that. Like when I was on sleep or something, I swear now he did. But you think it was you when you were just on? It's a possibility. Now that I know the effects, the extent of the effects that it can have on your brain, punch holes into your brain. How long does that last? Like that particular feeling. Just go there. Like it's only just 15 to 30 minutes for how long. What does this combo do? Makes you very energetic, very numb feeling. And you're having a lot of racing thoughts. Sometimes I hear things that it's not true. Right there. Sometimes you see things that's not there. But there are times that they don't eat, like shadow people. There's times that they're like for days on it. I'm not territorial with you. Me too, as a kid. And honestly, I didn't even tell you how the shit is said. How I don't have to even tell you how the shit is said, during those times. It's like, it's all a mixture of things, but I can't tell you what was going on.
Will it come back later, or is it just like?
It's almost like a blind tree. You might get bits and pieces here and there, you know, holding the time out.
So it's not like a dream where you were kind of over.
Yeah, you get bits and pieces in there, and then you never get the full. This, you're not sometimes someone's like, you did this, and you're like, no, I didn't.
Yeah.
Same thing happened when you get so high. So it's like, you just don't know. It's almost like the light is on.
Mm-hmm.
You know,
you're not about it.
Yeah.
So like in hindsight, how do you think that's what happened?
I think it's a possibility. So I was still crying a lot when they mentioned that some people get so high that their brain kind of just shuts down and they go, oh my God. Yeah. Yeah. Because I went at lost in the sand and just started crying and she was just like, what's wrong? And I was just like, I just don't know what to think anymore. And naturally just said, well, okay, things that I was doing before it was happening.
Yeah.
Yeah.
Cause you, I mean, it sounds like at least by like 1:30, you were pretty, at least learn to drive safely, you know, and all that. So kind of been for very long if you did consider it like that, right?
They say that hearings can last between up to an hour to 2 hours, so that you can move and function like you're home. You can in your head at home, but you're not.
Yeah.
Yeah.
So by the time you get in, you kind of come out, your memories get more clear, and you know, remember talking and, you know, operating car and going to different places. It's kind of click back in.
I'm going to make sure so it makes sense of everything. Then I can't make sense of what happened in front of the house.
Yeah.
That makes sense. No, I don't know exactly what happened.
Do you remember driving?
I remember driving back.
Mm-hmm.
I remember driving back home. No, hold on there.
I don't know, feeling. Do you remember any feelings or?
I felt a lot of numbness. I feel hard drugs. Honestly, they numb your feelings. They're not this depressing. Yeah. They numb your feelings. They numb just everything. Your body in general. Your lips, your nose, your skin, everything. It's not. Like that when somebody put their head in the sweat.
You would have later.
Later, yes. Just, it's devastating. Everything I know is the same thing, do this.
Leilani, Snail and I have been here with you from the start. I think you know that.
Yeah.
Her and I have basically been attached to your family, and I think both of us have an emotional connection to what happened.
Yeah.
And everyone right here wants to know what happened.
Just one budget problem. His name was Carol. What's that name, Carol? And that's what it does, and I'm so putting the pieces together for that, you know?
Yeah. You know,
And so what like I know what I fucked up on this, so what do they like? Just a little bit.
things happen. None of us are in that position, none of us are now. But the best way we can move forward is finding out that. And I don't want it to come down to some bad person telling us. I don't want there to be any guess. I'm tired of the stories from the media, and I'm sure you are.
Because we don't know what they're gonna say when it comes out that we found him. You know, and we've seen how they treated you for the last, you know, almost 2 months. And without your side of the story, it's gonna be whatever they want to say.
I don't remember hurting him at all. I don't remember killing him. I didn't do anything like this.
She's never coming back.
I remember coming home. Like I want to pay for the life. And so what did I do that? So it was like everything was just normal. I don't know, I home and I understand exactly what I was doing.
What about the next morning? 20 minutes in truck.
So when I woke up, devastated. When I looked at my and he wasn't there. I was really devastated. I just started screaming and calling everybody for help.
So when did you remember that stuff that happened? First, I think she means the Leech driver. Just saw it.
The dragon?
Yeah.
When I talked about it, I was close and sprayed her trust and just like, you know, just didn't think that I did something like that. I think we could do some drugs or pick up some drugs somewhere. I wasn't before. And, you know, what we were doing. I was going to try to make it in the hotel. I don't know what to do about the building. I didn't know all these things about the drugs I was doing. It just baffles me. Because I don't understand. Why am I making some crazy shit? I don't know.
I mean, when you talked about like the limits and things like that, or just Francie's mind, is there something that would, you know, things up when you're not supposed to be, you know, or like demanding some attention, you know, is there something that
He was a good baby. When I was trying to lay down, he was sitting there, last was so close.
was that ever annoying or just kind of really distracting?
It's cute, honestly. It's not actually seen to himself. We would sit there and laugh about it, trying to stay up his side, sleeping and jump out. You know, I'd peek around the corner.
I mean, I have 2 cats and I barely take care of them. I can't imagine 3 children and the stress and everything that happened that night.
The kids being upstairs, they're kind of worried.
Yeah.
It's why I love him so much. My cousin said that sometimes when people are drugs, we didn't realize that I'm not there, because they don't know us. And they're just all of that. I don't believe. I don't know what I'm going to do.
It's a hard thing to come to terms with, you know. I think that
I mean, I know exactly. Stop it, I don't know. I don't know that what I did or what happened or what happened. I don't know what I'm going to. Even that was like what we called out about being hypnotized. That's how much we wanted to figure it out. We were all down for it.
well, it sounds like the eating part, you know, at least in terms of removing it from allowing you to come from the outside in to help with that kind of thing too. Just kind of curious. So you woke up that morning, devastated, obviously, and you remember, you know, coming back from Zelia. When did things kind of click in that, you know, with the orange album, you know, the whole and all that? Like, what was going through your head?
I had working on the car, so it made sense. I go to the store. And the whole person over there only has what I was busy. So I was the only thing in my mind that made sense. That's why I don't know. You know. So when she's like the only person I know other except that you do more ways to work with. But I don't think I saw that. So, I don't know where something there. Really, we're coming back from the railroad tracks, like the bumps in the railroad tracks, so just takes that back in.
Yeah. Do you remember going into it in there? Like the turn or anything? Hearing anything? Because you gave us pretty detailed
Story about stuff I got like 360, and I was just like, no shot. I'm gonna go there, that's where I'm from. And I was thinking, how many must be? Or something, you know?
Yeah.
Which doesn't make sense. Oh, I'm coming morning, you know, I'm sure there was out of the brain, but it's so hard. Where was this picture like? I had to try to remember James and how did I don't because they say so things can come out of dreams. And you know, and I just don't have dreams. You know, you don't have no dreams or anything like that. I just don't understand it.
What do you think people are gonna say when it comes out that we found him?
Poor mother. I'm trying to show him. God knows exactly what they're saying.
What can you see of that?
There's no intention of it. It's not that I was planned out. It's not like I wanted to.
Do you think that you may have? But you know what, things weren't planned out, and like you said, you worked really hard in the last, month and a half to get clean and recognize safe coping with prisons and that kind of thing. But, a lot of times the wrong things line up, and something happens, and you remember leaving the dumpster, which is exactly how we were. We found him exactly in the middle of where we were looking, based on what he told us about coming to Grizzly and stopping at the dumpster. We wanted, because it was, so knowing all of that, knowing you're in a state and something happens and you try to fix it right away. And I think in some ways tried to make it go away like it wasn't real. And then you woke up and realized it was real. But I mean, we know that that's what happened, and it's maybe something you're gonna have to come on with, and we know that people have been very cruel. And the YouTuber culture and all that I had never experienced or seen. I had never seen anything like that. That they're in their own stories now. And so I really hope that you take a second to just kind of think of what your story would be, for yourself. Because the only way you can find peace and you give yourself peace and move forward for all of you is to realize and acknowledge what happened. And like you said, there was no premeditation, there's no planning, and frankly, I think if you would plan things, it would have not gone away, because it's not but your actions from that night are what brought us all here. And again, because you remember the trip to the dumpster is how we found, again, from head to toe, we found it. So I really want you to
I could and if nothing comes to my help, what I could possibly done, and I don't know what should possibly happened. And I was just not that I woke up and I was gone. And I'm gonna look down it. I don't know that anymore. This one I because I wouldn't be able to raise it. I wish I knew that.
I think we can all agree that something. We do figure out what happened. There's a lot of reasons for people right now. We're gonna know for science on that. We're gonna see what they have to say. I really don't think that you wanted this to happen. And you know, there's still your reason. And even when he's not here, he's still your reason. All three of them. And find out the reason for Quinton, that I think we all want to be. You know, this is what we know there's nothing to happen. And now there's two of you that know that story. You know, and hopefully Quinton's able to tell us. We really hope that you're able to know your own truth and kind of level, you know, your own action place, because there's no way for you to heal from it without being able to face it and see it as what it is. Like you said, it wasn't this long-term ocean's 11 keeper of, you know, harming your child. You know, you did harm your child, and you hit him, you know, and that's just, it's just facts. It isn't under I mean, I've never lied to you about anything. I've never said anything to you that I didn't know or back to be true. And I don't believe that you hit him, but you hit him in the dumpster because you had harmed him in some way for that. Wasn't fair. She came back and come out. Like, how scary is it though to think that you have a scalp? So how do you get it? I asked her if she thought I came back, and she said, I'll see if you would black out. You might not. So if you get a chance, you're just like when somebody blacks out from being drunk. You might not. Yeah. Your brain just didn't process it anyway. What's the last thing you remember before? Same. And then it goes to driving back from Zoe. So we've seen in the bed right when you got home or at some point, like you came home and did playing and you slept. Yeah, you know what? He's like, so that was like the 10 something, 10 40s. I just remember from the truck ride trip. And that's your last memory all of the night. You know, and then yeah. I said I had a rubber dress.
Now, at the end there, what did she arrive at ultimately for the period of time for which she was claiming a total lack of memory?
She said the last thing that she remembered was looking at Quinton and then driving back from Azalea.
Looking at Quinton after the arc ride trip.
Yes, and then blacking out and then coming back to it as she's coming back from Azalea.
And what was she saying in there about what caused her to start forming memories again on the way back from Azalea?
Hitting the railroad tracks.
Okay, so fair to say she's claiming something like a 2-hour plus total lack of memory.
Yeah, she would have gotten back from Arkwright shortly after 11, and then she gets back from Azalea around 1:30. So yes.
Okay. And is it fair to say that that period of time for which she's claiming the total lack of memory would encompass both the time period in which law enforcement believed the murder had occurred and the time period in which the disposal of Quinton's body had occurred?
Yes.
So just like the times of the crimes.
Yes, it is.
This next clip, what is this clip?
So this is us touching on her previous statement back on 10/12, where she's describing very vividly how she threw away the trash, and we're asking her to revisit that memory that she's had. And she's telling us that there's 2 trash bags, and then you'll hear me ask specifically whether or not Quinton was in those trash bags.
And does she outright deny that Quinton was in one of those trash bags?
She does not.
And this clip is later in time than the bit we just watched.
Yes, it is.
This is when y'all are kind of reminding her of her previous statements, which seem to conflict with what she's just told you about this total lack of memory.
Correct.
story with Sam and Brad.
There was another trash out there.
Was that what Quinton was in?
Before there was like 2 minutes later. And then I can't remember. I remember there was full of things. Green when I was trying to get with him.
Did you use a trash bag?
I don't recall if I had a trash bag. Okay. I don't recall if I think from before I left the house or when we came back.
Did we hear you, she said there was a trash bag in there, right?
Yes.
And then you said, is that what Quinton was in? Is that
Yes.
right? And at that point, did she say, well, there were 2 trash bags?
Yes.
And did we hear you ask her, did you use a trash bag?
Yes, I did.
And by that, did you mean, did you use a trash bag to dispose of Quinton's body?
Yes.
And what was her answer to that? I don't remember grabbing a trash bag.
That was her answer.
In other words, she didn't say, well, hold on, I didn't dispose of his body.
She did not say that.
Mr. Dean, how long is this setting up?
It is about 3 minutes, Your Honor.
Okay.
Or this should be the third one. Do you remember what it is that we're going to hear in this clip, more or less?
So we're challenging her on her many stories throughout the last 2 months and why she said these stories to us if she didn't have a memory, why she constantly changed, what happened that night, who went out to Azalea. It's kind of just our last crack at trying to find out what really happened.
Leilani, why did you tell us several times different stories?
I'm trying to you said it was 2 times that Brad sat there. And told me that him was sorry. He was like, no, mother, isn't it? And he watched me. I had no memory, so I know exactly where that. I know it was trash. Right now, I can make sense of this, and it was totally, original. And when he said there was no way to go original, I think it was the other theory.
Which is?
That was totally trash. Get out of the house first. Wait, Daddy.
But we know now that that trip to Azalea, Quinton was there. So go back to that statement you made to say on breath. You remember seeing the trash bag, looking into it?
I didn't look into that. Tired it was.
Right. So you didn't actually look into it?
The only thing I could do was spoon food.
You were pretty restricted though.
Because the smell, the spoon like shrimp pasta. Not even smell. It's the same smell here when you take it out of the fridge and throw it away.
So you remember wrapping it up?
I remember taking back here so I could throw it in there. It wasn't heavy at all.
Leilani, Jimmy, do you remember him being in that trash bag?
No.
We know at this point he was.
I don't remember that. I don't remember him being in a bag. I don't remember leaving the house with him. I don't remember that. I don't remember that.
Why did you tell us all the story about just all of these stories pretty much?
I'm trying to listen to it myself. He was the one that was the one saying, I saw you in the trash and throw it away.
Let me show you something. It's gotta help, but what Evelyn's asking right now. This is a very small fraction of the mountain. What that looks like a hill is trash. And everything to the left and right of that is trash. You see how little those people are. Do you think that we could have found him if we didn't know that you put him in the dumpster and we knew exactly where that dumpster went? Yeah.
Did we hear her say the word theory at some point in there?
That's what she refers to it, yes.
What was the theory thing? What was she saying?
She's saying that every time that she lied to us was her sharing her latest theory.
In other words, she wasn't claiming that she was making factual statements about what happened. She was saying she was just kind of throwing out theories.
Yes.
She was describing was she describing the Oragel story as just a theory that she had proposed?
Yes.
And was she saying that she had only proposed it because, well, she had come to and found Oragel and was trying to figure out how?
Yeah, she said she found it in her vehicle, and that's the only thing that made sense to her.
And did she describe her story about throwing away trash as just a theory that she had come up with in response to Brad asking her whether she had thrown away trash?
Yes.
Now, I want to just ask you about a couple features of these prior stories that she's referring to as theories, okay?
Okay.
You talked to her on October 5th when she first launched the Oragel story, right?
Yes, I did.
Did this story include who she had gotten it from?
Yes, it did.
Did it include where she had gotten it?
Yes.
Did it include when she had gotten it?
Yes.
Did it include why she had wanted it and obtained it?
Yes.
Did it include details such as how many tubes of Oragel she got and how many were opened already and how many were unopened?
Yes.
The story about throwing away trash that she gave to Special Agent Snyder and Special Agent Solomon on October 12th, did that include such details as specifically what the trash was?
Yes, it did.
What it smelled like?
Yes.
How long it had been in the car?
Yes.
When she first registered the odor of the trash?
Yes.
What kind of trash bag it was?
Yes.
What color the ties on the trash bag were?
Yes, it was a very vivid story.
An admission to having looked inside the trash bag before throwing it away.
Yes, she said that.
An estimate of how much the trash bag weighed.
Yes.
And statement about the exact physical mechanics of how many hands she used to put it in the dumpster.
Yes.
You had either conducted those interviews or observed them prior to this interview, right?
Correct.
Did any of those things sound like mere theories to you at the time that she said them?
No, they did not.
Now, in this interview, particularly in the first bit we watched, the 20-minute bit, was she asked at some point by you, I think we can all agree that something did happen.
Yes.
And did she nod her head yes in response to that?
Yes, she did.
Was she asked, do you think you may have killed him or something to that effect?
Yes.
And is it the case that she was just not able to give an answer to that or just didn't really say anything?
That's correct.
Was she, at some point, did Special Agent Solomon say, you harmed your child and hid him, or words to that effect?
Yes, she said that.
And is it fair to say that the defendant just did not affirmatively dispute that? She didn't say, no, I didn't.
She did not.
And separately, did Special Agent Solomon say, you hid him in the dumpster because you had harmed him in some way?
She said that.
And did she also fail to dispute that statement?
Yes, she did.
One moment, please. No further questions, Your Honor.
Any questions?
I do, Judge, but I was going to say this might be a decent time for a little break in case it takes a minute.
All right. The time now is 2:36. Let's just take a few minutes to shift. Let's make it about 10 minutes. That will be 2:46. All right. All right. We're in recess.
Jury is exiting.
Thank you, Smith. And with that, we're in recess. Thank you.
Wow, unbelievable. Unbelievable. I think Leilani's toast, isn't she? She's a goner. She's a goner. I love how I couldn't hear a lot of that interview. Like with those interviews, the audio is just so bad. I can't tune my ears in to some of them. Some of them I can tune my ears in. Others I just can't. But anyway, when Detective Lemon said that every changing story, Leilani explained as, well, it was just my theory. This is just my theory of what happened. Okay, all right. No, it's not your theory. She's just done. She's done. I honestly, I need this trial to be over with now. I've heard enough. There's absolutely nothing that is redeeming. Nothing. The defense has had no defense. Every witness just leads you down the same track. There's no. I don't think the state needs to go any further with it. It's done. It's done. What's going on in Briefcase Boone? Briefcase Boone. The psychologist, there's the doctor that they had on this morning, the forensic psychologist, he was very good. I liked him. Like, he was talking in generalizations, but I think he was good with the jury. I think the jury would have liked him. But this doctor they've got on now, another psychologist, she's boring. She's boring me. Honestly. So I kind of a little bit tuned out from her. And if she's boring me, she's boring the jury. So I've got to listen in a little minute because they've moved the camera back to Sarah.
Objection sustained.
Oh, it's an objection. Sustained. Objection sustained. Let's have a look at Delphi here for a second. Oh. Do you remember the motion that Andrea Burkhart put in about getting records? So like 10 pages, including law. So Andrea Burkhart's motion for leave to intervene and for public access to court records filed October 21st, reviewed and denied without hearing. Indiana Trial Rule 74D limits the availability of the audio recording of or proceeding to a party. As Andrea Burkhart is not a party to these proceedings, the court is not required to provide the recording. The balance of the motion to intervene is merely a complaint about how the court is conducting a trial. Well, I saw that coming, didn't you? Yeah. Yeah, I'm absolutely shocked. I'm absolutely done for with that one. Done for, I tell you. Done for. Actually, I'll save that. Okay. All right. What else have we got here? All right, so I don't know where Simply Strangers got this from, but it must be something from the news. Abby's autopsy was first. She was wearing a black hooded sweatshirt, blue jeans. SA kit was administered. Court said there was no overt injuries indicating a sexual assault. Deputy Prosecutor Jage Luttrell asked Court if that meant there was no sexual contact. Court answered it simply meant there was no trauma left behind as evidence. Oh, Wabash Valley News. Okay. Abbey continued. He observed no blunt force trauma or defensive wounds. Saw a faint linear mark, a reddish mark near the bottom of her lip. He told the court it could have been from duct tape or cloth, but added there's no glue or tape residue and provided no definitive answer as to what may have caused the mark. She may have already had that mark. Do you know what I mean? So I don't think that's definitive at all. Abby suffered a single mortal wound to the left side of her neck that hit the jugular vein. He estimated she bled out in 5 to 10 minutes and said death was not instantaneous. He said she would definitely have had the chance to react to her injuries. Sarah Carbo testified that she saw a bridge guy walking down County Road 300 North by the cemetery around 4 p.m. It was actually 3:57 while she was driving by. He was hunched over and plodding along with his hands in his pockets. I looked at him, but he did not make eye contact with me. She was driving by. Who makes eye contact with drivers driving by? The man's clothes are bloody and muddy. BS. With blood visible on his lower legs, feet and ankles. The rest of him was muddy, as if he had fallen down a hill or into a muddy creek. Was his pants wet? I mean, look. If he'd gone over the creek, his pants would be wet. His jeans would be wet. If he'd gone through the creek with the girls, that man's jeans would be wet. Not as muddy. She waited 3 weeks to contact the police. She blamed in her inaction on trauma and panic, telling the court she was overthinking and having a moment. For 3 weeks, she look, this is the most unreliable witness I think I've ever seen. She saw an officer taking tips at a roadblock and saw this as a sign to reveal what she had seen. She helped police identify a vehicle on cameras from the Hoosier Harvester store. The state didn't ask her opinion on whether bridge guy was Richard Allen. Is that it? Yeah, that's it, I think. Oh, no, there's more. These are out of order, I think. He couldn't tell if the attacker was right or left-handed in either case. In his autopsy reports, Court wrote that some of the wounds were serrated and suggested multiple weapons may have been used. He told the defence during a February deposition that there may have been some class of serration in some of the wounds. He later told the court he was unsettled over the serration issue. He now believes the wounds could have been caused by something like a box cutter. He said the minimum number of weapons needed for the murder was 1. No shit. No shit. Cross-examination was more difficult and charged at times, however, and Carbo became combative with the defence. These are really out of order. I'm reading them in order they appear, but they're out of order. Defence attorney Andrew Baldwin said a 2017 statement said the man was muddy and not bloody. He noted that blood did not appear in the transcript. This led to an objection from the state. Baldwin mentioned a second follow-up interview from Carbo, in which she said mud and not blood. Carbo responded that she did mention blood, but police didn't write it down. Police didn't write it down. She also said her videotaped interview was lost due to problems with the police recording system. The state had said some early interviews associated with the case were lost due to an error. This is bullshit. Absolute, complete bullshit. Baldwin gave her a transcript of an interview and asked where she said blood. I do not see it here, but I do remember talking to an officer about it. Where's he gone? Where's he gone? Where's he gone? Oh, Baldwin brought up a third interview from 2019. In that one, he said Carbo used blood and not mud. I understand you're doing your job, she told Baldwin. I saw a man on the side of the road with mud and blood, and that's that. All right. Baldwin took issue with her description of Bridge Guy's coat colour, saying Carbo didn't see his coat was blue until after the infamous photo was released to the public. Baldwin said she called it tan when she recalled it, while she recalled it was more brown. Something she explained by reminding the court that Bridge Guy was covered in mud and blood. Carbo's frustration was apparent during the cross-examination, becoming combative and sarcastic at times in response to the defensive questions. When asked why she waited 3 weeks to talk to the police, she replied, cowardly liar here, just a chicken. Baldwin said Carbo told police that Bridge Guy had effeminate eyes. She didn't recall making the statement and asked if Baldwin was romanticising her deposition. He wanted her to check the transcript, but she replied, no, I'm good. We are back. We are back.
And so, Mr. Hilliard, are you ready for cross-examination? Okay, is the state ready to proceed as well?
Yeah, sure.
Okay, please bring in the jurors.
Jurors entering.
It appears that everyone is not ready. So the jurors who are present, if you'll go back to the deliberation room, that's fine. On second thought, it appears that things are working out. All right, excellent. Do y'all want to change the order?
Yes.
I can tell that was going to be a thing. Everybody, please have a seat. Okay. So, ladies and gentlemen, we're going to move now to further testimony. Okay. And no one discussed the case or did any research? All right. Thank you. Mr. Hilliard.
This is the first time I really had a chance to speak to Leech, so I'm going to go way back.
To the beginning for that reason, okay? Give me 1 second. I picked up the wrong path. So you arrived on scene at 10:30 on October 5th, correct?
No, after 12.
After 12? Okay. And how long were you on scene on October 5th?
On scene, probably about an hour.
All right. And at what point in time did you take Miss Simon, Mr. Youngkin, and Mr. Simon over to the precinct that day?
I asked one of the patrol officers and some of the detectives to have them transported probably within that hour.
So probably around 1 o'clock then, but just trying to get a general idea.
Yes.
So on October 5th, around 1 o'clock, all three of them went over to, I guess it's the police.
The
precinct?
headquarters?
Yeah.
Yes, sir.
And how long were they there on October 5th?
Until about 2 a.m. the following day.
So about 13 hours, right?
Yes, sir.
And over the course of the trial, we've seen a number of interviews during this time, correct?
Yes, sir.
And during that time, you were also speaking with, I'm going to assume, I'm not trying to put words in your mouth, you're speaking with Miss Simon, Mr. Youngkin, and Mr. Simon, as well as others at the time, but those were the three main ones, right?
That our team spoke with, yes.
Yes. Okay. So that was 13 hours on the 5th to the 6th. When did you next speak with Miss Simon or have your team speak with Miss Simon?
We were in communication with her for probably the next 2 weeks, almost every day.
Every day? When you say ran communication, I guess that means phone calls?
Yes, sir.
Okay. And when was the next, I guess, in-person interview?
October 8th,
How long was that one?
almost 2 hours.
And that was at CCPD as well?
No, that was at the FBI office.
And 1 second, I'm running out of room here quickly. And when was the next one after that?
October 12th.
And how long was that one and where was that?
That was almost 2 hours as well, and that was at the FBI office.
And during this time frame too, this is the phone call? You still having phone calls during this 2-week time frame?
Yes, sir.
All right, so it's 13 hours on the 5th, 2 hours on the 8th, 2 hours on the 12th. When exactly was the hotel room video and audio?
What part of it?
The actual time they were in the hotel room when y'all were videotaping it.
The 8th and 9th.
That was October 8th to 9th, correct?
Yes, sir.
And during the same time frame, you were wiretapping Daniel Youngkin's phone from, I think, around the same time, October 8th or 9th, for about 60 days, right?
Yes.
Intercepting all of the phone traffic between him and her.
Yes.
And just, not that it matters, a rough estimate is even after you arrested Miss Simon, you still intercepted his phone calls between them, correct?
Yes.
So that was at least, generally speaking, between October 8th, 2022 to December 8th, 2022, correct?
Yes.
All right, so that's going on at the same time the other interviews are going on, right?
Yes.
So October 12th, I'm sorry, was the next in-person interview. When was the next interview that your team did of Miss Simon at that point?
After October 12th?
Mm-hmm.
October 31st.
All right. And how long was that one and where was that one?
That was at the FBI office, and I believe that one was also probably 2 hours.
2 hours. Okay. And the next one after that?
Would be her final interview when she was arrested.
And what day was that?
That was on November 21st.
And that one was how long?
3 hours.
And so from October 5th to November 21st, were you still in constant contact with her?
The team was.
The team was. And by the team, you mean yourself, Agent Solomon, Agent Schneider, and anyone you delegated to do that, correct?
Yes.
All right. Now, and you said that on, I think it was November 21st, she expected to be arrested when she came in, correct?
Yes.
And you asked her to come in, correct?
Yes.
And she came in, correct?
Yes.
All right. Now, we've seen some of the excerpts here that you put up here today. Now, let me ask you this. What interrogation technique were we just witnessing on this particular video?
I don't have a name for the technique. We were having a conversation.
All right. Well, you said you don't have a name for it, but you've gone to the academy, correct?
I have.
And you were trained in interrogation techniques, correct?
Yes.
And what interrogation techniques were you trained in?
I don't have the name for the techniques. My way of doing it is just making sure I have the full story. And if I don't understand anything in somebody's story, I just keep asking questions until I do.
Okay. So in this particular technique, though, which we just witnessed, and we've seen the entire time, is it safe to say that you're putting individual stressors on the interview subject?
In which interview?
All of them.
It depends on what you would say is a stressor. We're talking about her dead child, but
Okay. Well, and that's my follow-up question. Wouldn't you think speaking about that would be a stressor?
yes,
Okay. And wouldn't you think that speaking about that would evoke an emotional response?
yes.
Okay. And you seem to have had opinions about that emotional response, but what have you been trained that is the appropriate emotional response? Do you have a level?
Can you restate your question?
I can. So if you are overly hysterical, then you're overly hysterical. If you are not hysterical enough, then you're not hysterical. How do you gauge the appropriate response level to your questioning for you to be satisfied? What's the right answer? What could ever be the right answer?
For what appropriate reaction she had?
Yes.
I'm basing that on previous interviews I've done with families that have lost their children.
Right. But every individual is different, are they not?
Yes, sir.
Okay. So in this particular case, a number of times Mr. Dean has asked you a number of questions and you said it wasn't emotional enough or it was too emotional, hysterical. And how do you make that determination? What is the appropriate objective standard by which you can judge that?
I believe I focused on the October 5th interview when she would do the screaming and yelling portion.
And that was when you made your decision, correct? October 5th?
Decision about what?
As to how and where you were going to focus your attention in this investigation.
No.
Okay. Then when did you decide that Ms. Simon wasn't your prime suspect?
She was our prime suspect, you mean?
I said, when did you decide that she wasn't? If you said you didn't do it on October 5th, okay, so you're saying she wasn't your prime suspect on October 5th?
No, we looked at all three of the adults in the residence as possible suspects.
Okay. So that being said, you looked at all three of the adults. Did you ever look outside of the residence as a possible suspect?
Yes.
Okay. And what did you do to pursue any of that?
Outside the residence? So we did a canvas, as we've previously talked about. No leads came up with that of any suspicious persons around the residence. We set up the tip line that did not prove any other suspicious persons. We spoke with probably every single family member of this family in Savannah. None of those had any guesses on who it could be, including the three people that lived there.
And let me ask you this about your interviews with Ms. Simon. All of the interviews, she was free to walk away or not engage in those interviews, correct?
Until the final one.
The final one was a little bit different, correct? Because you already had warrant to that.
Yes.
Okay. So and even knowing that, she still came to that, correct?
Yes.
Okay. Now, Mr. Dean asked you a question about whether or not she denied something, but not denying something is also not admitting something now, is it?
No.
They're not the same thing, are they?
No.
Okay. So, and in my recollection was, I don't think she's ever in any of the interviews admitted to harming Quinton, has she?
No.
Now, in the last interview at that point in time, had you ever determined a manner or cause of death for Quinton Simon?
I have an opinion on how he died.
I didn't ask you your opinion. I'd ask you if you determined, has a doctor made a medical determination as to manner, method, or time of death?
No, due to the remains, we were unable to find that.
So that's no. Okay. And that being said, when you were interviewing Miss Simon, on that last particular day. You focus on a lot of things that weren't said, but she never said that she killed Quinton, and she never said that she disposed of his remains, did she?
She said she did not remember.
Now, you said you have an opinion, but opinions are just that. They're not based, they're just your opinions, right? I have opinions, you have opinions. People have opinions, correct?
Yes.
Okay. And opinions are not evidence, are they?
No.
That's all the questions I got, Judge.
No redirect, Your Honor.
Yes, ma'am.
State may call its next witness.
May we have a moment, please, Your Honor? Your Honor, subject to verifying that all of the evidence that we've offered has been formally introduced and admitted, the state rests this case.
And so with that, jurors, I'm going to ask you to return to the deliberation room at this point.
Jurors are exiting.
Jurors are clear, Your Honor.
Thank you, Deputy Smith. Everyone may have a seat. Okay.
The state just wanted to verify our exhibits, and we should have exhibits 1 through 94, and 94 is an A and B, in evidence with the exception of 83.
Microphone.
Sorry. What I was saying was the state should have exhibits 1 through 94, which is an A and B exhibit in evidence with the exception of state's exhibit 83.
So 1 through 94 A and B, but not 83.
Not 83. We just wanted to verify that with the clerk.
Thank you, too. Thank you. Mr. Clerk? Madam Clerk. Okay, and that's what you show is in evidence.
Thank you very much, Your Honor.
Thank you, Ms. Parker. And then, is there any motion by the state? Excuse me, by the defense?
Yes, ma'am.
Mr. Purse?
Here, let me give Mr. Purse the microphone, Judge.
Just a moment before you begin, Mr. Purse.
Your Honor, at this time, I'm going to focus my argument as to a motion for directed verdict. Just so we're all on the same page, I'm focusing on counts 1, 2, 3, and 4. And I'm going to take them kind of in separate batches and then all together with my final thought.
All right.
With respect to counts 1, 2, and 3, that allege that Leilani Simon committed malice murder and felony murder of Quinton Simon, the defendant moves for a directed verdict of acquittal. First, there's no direct evidence to support these claims. The state has presented theories and its conclusions, but has presented no direct evidence that Leilani Simon committed these crimes the way they're charged in counts 1, 2, and 3 in the indictment. I think the medical examiner's testimony is significant. She expressed no opinion about the manner of death, the cause of death, the time of death, and even as an expert in her field, couldn't even express an opinion that Quinton Simon died as a result of the commission of these crimes. That leaves us with circumstantial evidence. In Georgia, and I'm quoting Official Code of Georgia 24-14-6, quote, to warrant a conviction on circumstantial evidence, the proved facts shall not only be consistent with the hypothesis of guilt, but shall exclude every other reasonable hypothesis, save that of the guilt of the accused. With respect to the circumstantial evidence argument connected to the murder claims, again, the medical examiner testimony is extremely significant because what it presents and what it leaves out raises lots of hypotheses as to what happened to Quinton Simon and does not only establish the guilt of Leilani Simon as alleged in the first 3 counts of this indictment. With respect to count 4, that alleges concealing the death of another. Concealing a death is against the law in accordance with Official Code of Georgia 16-10-31, which provides that a person is guilty of this offense, and I'm paraphrasing the statute, when a person conceals the death of any other person and does so to hinder a discovery of whether or not such person was unlawfully killed. In this instance, the medical examiner's testimony again failed to establish that Quinton Simon's death was the result of any unlawful act. Basically, all 4 counts of this indictment, I should say, is grounded in a bunch of theories and the state's speculation and conclusions. With respect to that, in suggested pattern jury instruction 1.20.20, Georgia law provides that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a suspicion or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. At this point, the state's evidence is ground in speculation and grave suspicion, but not on facts and not on evidence. On behalf of Leilani Simon, we move for a directed verdict of acquittal with respect to counts 1, 2, 3, and 4 of the indictment. Thank you.
Thank you, Mr. Purse. All right, Mr. Dean.
Your Honor, I'll be brief. We've presented sufficient evidence for the jury to find, based on both circumstantial and direct evidence, that the defendant is guilty of all 4 of those counts. The Wyatt case is clear that when we allege that certain facts are unknown, such as manner of death or or certain other facts in the murder counts, that those become material allegations that we have to prove. And I think that Mr. Peirce's understanding of the medical examiner's testimony is exactly backwards. It does not support a directed verdict on any of these counts. In fact, it was offered to prove the material allegation that certain facts are unknown, and it does that. We've said in the indictment that she killed him in a manner unknown to the grand jury, and that was the point of calling the medical examiner to say, I couldn't do an autopsy because of the condition of the remains. And so we've proven that. Circumstantial evidence does, a circumstantial case does have, the evidence does have to exclude all reasonable theories other than guilt. And we've done that by presenting affirmative evidence that there was no medical event. There was no accident. The defendant was asked repeatedly about that and denied it each time. And further, her actions after the fact were totally consistent with any type of accident. There are only so many ways to die, and we've excluded all of them, but in intentional act of violence that resulted in Quinton's death. In concealing the death, requires that you conceal the death of another such that it hinders, such that you hinder the investigation into whether the person was unlawfully killed. I don't know whether there's ever been a more straightforward body of evidence in support of a concealing the death charge. I could go on. I hope and doubt that the court needs me to. So I'll wrap it up with that here.
All right, thank you very much. I am going to find that based on the argument made by the state, the court finds that there is sufficient evidence that has been presented for the jury for the charges in the indictment to be considered. So motion for directed verdict is denied. All right. Are there any other motions from the defense?
We probably need to engage in the right to testify colloquy at this point, Judge.
We do. So I'm going to ask Ms. Simon to come up to the witness stand. And before going to the witness stand, if you'll be sworn.
Raise your right hand. Please clear.
The evidence you shall give the court on the issue pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Ms. Simon, just have a seat on the witness stand, please. Okay. All right.
You want me to do it? Judge?
I'm going to start out with Ms. Simon. Ms. Simon, please state your full name.
Leilani Murray Simon.
Okay. And you're doing the right thing, just talking to the microphone so the court reporter can get it. I think you've heard me give that instruction a couple of times.
Yes, ma'am.
All right. Do you understand that you have a right to testify?
Yes, ma'am.
And that if you want to testify, no one can prevent you from doing so?
Yes, ma'am.
Do you also understand that no one can make you testify? No one can compel you to testify. Do you understand that as well?
Yes, ma'am.
And you have the right not to testify if you don't want to. Do you understand that?
Yes, ma'am.
All right. Do you understand that not you're a lawyer, but you personally are the one who decides whether or not you will testify?
Yes, ma'am.
Do you understand that if you do not testify, that upon proper request by you, the court will instruct the jury that your decision cannot be used against you?
Yes, ma'am.
In fact, the court will instruct if you decide not to testify. Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you choose to testify, you will be examined by your counsel and cross-examined by the assistant district attorneys in AUSA?
Yes, ma'am.
All right. Do you feel a need to have any additional time to consider whether or not you will testify?
I've been given plenty of time by my attorneys.
notified weeks ago
All right.
about this.
Do you need any time to talk with him in private about this?
No, ma'am.
And so do you personally wish to testify or not?
I do not.
And with that, I find that the defendant, Leilani Simon, has decided not to testify with a complete understanding of her rights.
Yes,
Before you step off the stand, are there any further questions?
Just to follow up. Is anyone forcing you to not testify or to testify?
No, sir.
Your choice is made freely and voluntarily?
Yes, sir.
Okay. And you've had adequate time to speak with me and Mr. Person about your choice, correct?
Plenty of time.
Okay. Just have to make sure. All right. And that's the only questions I had, Judge.
All right. Ms. Simon, you may step down.
Thank you.
Let the record reflect that Mr. Hilliard is taking some time to speak with Ms. Simon in private at the table.
If I could just have a couple minutes there, because I want to go back in the back and explain to her. She had a couple of questions about what happens next. And I probably need a few minutes away from everybody to go talk to her.
Let's do that. It's about 10 till, I can't tell the time by that clock. It is 3:20. Okay, so let's step off until about 3:30 or so. Okay, we're in recess.
Best decision Leilani Simon has ever made in her life not to testify. She'd have got absolutely ripped apart in cross-examination. She really would. But, yeah. But we got another break because that's what we're good at here. That's what we're good at here. All right, well, are the defence going to put on any other witnesses? I doubt it. I want to say no, they're not going to put on any witnesses. Yeah, smoke break. Oh dear. So, as long as the defence aren't going to put on any witnesses, there won't be a rebuttal and the jury will get the case. Well, there'll be closing arguments. So, we could be done. Didn't sound like there were any, no. But the defence has to formally rest. You know, say no, we're not doing it. I can't think of any witnesses that they could actually call that would do them any favours. Figured it would be done by Friday. It may well be. We're only Wednesday. Boone could also be done by Friday. I think there's a little bit more to go with Boone, though, because the defence is putting on its own witnesses. And this psychologist, she's been on the stand forever. And I've kind of zoned out from her, honestly. She's a bit boring. So, So because they've put on witnesses, though, the state has a chance to rebut if they want to. Guessing 3-hour deliberation. Should we do a little poll? Let's do a little poll. All right. I have to go into YouTube to do this. All right. So this is what you think the jury will find. Not what you find, what you think the jury will find. The jury will find... Can't even spell Leilani now. Leilani guilty. Not guilty. Or hung jury. All right. Start poll. All right, you can vote now. Diabetes. Yeah, I think they'll come back fast. I really do. I think they will come back fast. Can't see the poll on StreamYard. I think Boone has a small chance, particularly after the DV testimony. So do I. I think she's got a small chance. I think it's a very small chance. She'd have to have multiple jury members prepared to, go out all out to bat for her. I think just one lowly voice who is like undecided, I don't think would do it. I think there would have to be, a few jurors who would really, really want to argue the DV case for her. And I could see manslaughter. If manslaughter's offered, I could see manslaughter. I absolutely could. I don't think she'll get away scot-free though. But this one, Leilani, I think the state has done more than enough. For Boone, it's the video that does it. But with this, just everything. I don't think there's any wriggle room at all for the jury to consider that someone else might have done it, or that Quinton might have died by natural causes. Because if a baby dies by natural causes, you don't throw them in a dumpster. You just don't throw them in a dumpster. So where's my poll gone? I've lost my poll. Lost my poll. I've lost my poll. Oh, there it is. All right. I'll give it till Tammy comes back to end the poll. Currently, we're sitting on 93% guilty and 7% hung jury. Interesting. Interesting. See, I don't think so. I don't think there's going to be a hung jury. I don't think, even if there's one juror who's not sure, I think there'd be a lone voice. and lone voices, unless they're absolutely adamant, end up, saying, oh, well, yeah, you persuaded me or whatever. Even if they don't fully believe that they're persuaded. But you never know. You never know. Casey Anthony, anyone? Who'd have thought that would have happened in Casey's case? So there's that. But we've had 97 votes so far. So you've got plenty of time still to vote if you've not done. It's going to take 40 minutes for Tammy to do whatever she does.
Yes, sir.
Just checking into Boone, seeing what's going
State
on.
attorney talked to you about power and control.
Oh, it's still
an abusive partner will use power and control over the victim is a.
It's still the same witness. Oh, we've gone up to 8% hung now. 103 votes. All right, maybe I'm seeing this as too cut and dried. It is interesting. Like, even if I knew nothing about the case, just watching the trial, I don't think I would have any doubt about. I think the only thing is they don't have a cause of death. I think that's the only thing that would possibly sway a jury into reasonable doubt. But I think, honestly, I think that's why the state did go overboard a bit with the landfill witnesses, just to, explain just how difficult it was. And, the compaction and all of that stuff, how difficult it was to get remains back in that horrible environment. Where's the badge that said you voted? I don't know. Did you get a badge? Yeah. Casey Anthony's verdict was shocking. But the state didn't meet their burden, and that's that. Honestly, I think the state were too complacent. It's a long time since I watched Anthony's trial, so from the bit I can recall, I think the state were too complacent. I think some of the witnesses weren't fully understood, and they underestimated Jose Bias and the way that he put on his case. I think there was enough reasonable doubt that the jury couldn't do anything else. They had to vote not guilty. So anyway, I'm going to hop over to Boone a second because we're back onto Sarah. So I'm just going to hop over and just check out what's going on. I'll be back in a sec though. right, looks like we're heading to a break in Boone.
Let's go ahead and take a recess, a comfort break for any of us, and then we can address any argument with regard to the any other evidence that the defense may be seeking. Let's come back here in about 10 minutes, so 4:13. Okay? All right, thank you. We'll be in a short recess.
Oh. All right, speaking to both channels, we're on breaks on both channels. So if you've got the audio for both channels on, you'll need to temporarily mute one or else you'll get a horrible echo. So we've got a 10-minute break over in Boone. I've got to say that psychologist bored me somewhat. The one this morning was great for the defense. I think the jury would have warmed to him. I'm not saying what he's saying was correct, but I think they would have warmed to him. But this one, I think maybe she could potentially have lost the jury a little bit. And then Leilani is not going to testify. Judge Tammy got her up on the stand and, asked her, was she going to testify or not? So it was like bated breath. Is Leilani going to actually testify? But she's not. She is not. So looks like very soon the jury are going to get the case in Leilani's. I don't know how close we are in Boone, though. She was a word warrior. She was. Yeah, it was too long. It was too long. And I don't think it helped. I honestly don't think it helped. I mean, you might argue it was thorough, but I don't know that it helped her. But if you have a handful of jurors who are persuaded by the domestic violence defense, then she does have a small chance. She does have a small chance. I think the prosecutor had good questions on cross. Yeah, the prosecution have been good in Boone. The prosecution have been good in Leilani as well. I think the case actually speaks for itself in Leilani's. But we do have a poll going over on Leilani's. It has been another long 10 minutes for Judge Tammy. It's quite the ride, yeah. Been here and there for 98% of the time. It's this doing 2 trials thing. It's not something I want to repeat in a hurry. It takes an awful lot of brain power on my end. And remembering what I've got muted and what I don't, and yeah. And then in the midst of it all, we've got the shit show that is Delphi. How many females on the jury in Boone? I don't think I've seen a gender breakdown, but then again, I haven't checked, I don't think. But having a large number of women on the jury for a DV case, it could go either way. It really could. Because you might get some who are sympathetic, but then you'll get others who will, they'll do what we call defensive attribution. They'll make a defensive attribution. So they'll say, it's her fault. Like, it's her fault. She should have left. And really, it's a self-defense mechanism. It's basically saying, that wouldn't happen to me because... Oh, Judge Tammy's back. She's back. All right. gonna mute out here on Michelle After Dark. All right.
Okay.
Quickly on
So
Michelle
we're back
After
on the
Dark.
record in SBCR
We've got 20. What have we got?
Ms. Simon is present.
91% guilty, 7% hung jury, and 1% not guilty. Oh,
Is there anything that we need to take up before we bring the jury back in? Okay.
Is the plan then to bring the jury out and have the defense rest and present?
Yes.
Send the jury home and talk about charges?
Yes.
Okay, thank you.
That was so succinctly put. Thank you. Bring in the jurors, please.
Jury room is clear, Your Honor.
Thank you, Deputy Smith. All right, ladies and gentlemen, please have a seat. There were no discussions about the case or research. All right, very well. Mr. Hilliard?
Yeah, the defense rests.
All right, thank you. And with that, ladies and gentlemen, we are going to release you for the evening. There are some legal matters that we need to take up outside of the presence of the jury. I'm going to have you come back tomorrow at 10 o'clock a.m. Please continue to follow the court's instructions. Do not discuss the case. Don't let anyone discuss the case with you. Don't watch television shows. Do not do any separate research. Okay? All right. Very well. Thank you very much.
Jury's exiting.
yeah, called no witnesses. No witnesses, defense rested. I thought they might. I did think they might. I really thought they might rest. I couldn't think of any witness that they could bring that would do her any justice, would do anything at all to redeem it. I don't think there's any coming back for Leilani. I just don't. I don't think there's any coming back for her. Catching up on 2 times speed. Ooh. No cavities. I wish I could say the same. I've got loads.
Thank you, Smith. Okay, so I've received, of course, the requested charge from the
Yeah,
state.
she's going down.
I've had an opportunity.
I honestly cannot
sets
see Leilani Simon
do we have
getting away at all. I cannot see it.
Okay.
She's not
So
going
I'll
home
have,
ever.
Proposed set
Slightly, a teensy chance with Sarah, based on the defence actually putting on.
10 o'clock.
Putting on a show there.
Take up anything earlier than that. I expect us to.
What sentence do I think she'll get? Life without parole.
It may very well be there.
Or life without the possibility of parole for a very, very long time.
Issue with
If the judge is feeling
the charge should be.
Because it's a
And
second
so that
degree,
may
isn't it?
take some thought. I certainly
So
would like to hear what you have to say.
no, it's different in
Just to get
Georgia.
those
It
requested
confuses me in
charge
Georgia. So we've got
what you have
we've
to
got a
say.
malice murder and
Let's
felony
get those
murder.
requests to charge
So
to you in just a minute or
they've got
two,
two
and then we
different
can go
options.
through.
But anyway, I'm over talking. I'm over
With
talking the
that,
judge.
we're in brief recess.
I was over talking the judge and I didn't hear a thing she said. So what are they talking about? Well, we're having another brief recess. Yeah, Leilani's the female Adam Montgomery. Oh, 10 o'clock tomorrow for the jury. Did they accept the request to acquit? Of course not. No, that was denied. If they'd accepted the request to acquit, she'd be going home tonight. But no, so that was denied, and the defence has rested their case. So the jury have been sent home for the night. So because the defence has rested without any witnesses, there's no need for the state to rebut. So it means that we've got closing arguments in the morning, and then the jury will get the case. And that's it. So I don't know why we're having another brief recess. Brief recess, discuss charges. Yeah, but why do we need a recess? Going over to Looney Booney. Looney Booney. Briefcase Boone is the best one, I think, from today. Briefcase Boone. Yeah, verdict tomorrow, yeah. I think so. I think we'll be on verdict watch. I'm gonna make a prediction for Leilani. I'm gonna make a prediction. I'm gonna say less than 3 hours. I'm gonna say less than 3 hours. Having said that, they do have, if they want to, they do have quite a bit of video evidence to go through, if they want to. But it's Friday. Oh no, it's Thursday. I was gonna say, if it's Friday, I don't know whether it's an intentional thing or whether it's just a psychological thing for the jury. But if it's a Friday, they want to get it done. They want to get it done so that they don't have to come back on Monday. But as it's Thursday, they might take their time. But I think we'll if it goes into Friday, we'll definitely get a verdict Friday. But I honestly can't see it. But then again, who knows? Wait till Delphi goes to the jury. Oh, don't. I'll be so anxious. So anxious about it. I really will. So anxious. Shame my name wasn't Barbara, then we could have called her Barboon. Oh, that's bad. Barboon. That's bad. Verdict by 3 p.m. tomorrow. I think so. Because closing arguments, so 10 o'clock, closing arguments take a couple of hours. They'll go for a long leisurely lunch, and actually they might just buy the jury lunch and they might just go straight to the deliberation room. How exciting. What is Quinton's date of birth? Oh, they did say. I honestly can't remember. My head is just like broken with all of these trials. Closing arguments and jury instructions before lunch and then verdict by 3. I concur. That could well happen. Could well happen. Maybe unethical, but Richard Allen's verdict is my true concern here. Me too. Me too. I absolutely cannot call what's going to happen with the jury there. I cannot call it. I just can't. Yeah, what's happening in Delphi is absolutely sickening. And I just hope it's a not guilty. I mean, look, I would say, oh, all right, judge is back in Boone, so I'm gonna mute out there.
Appearances for the state. Defense. Ms. Boone is seated at counsel's table wearing the same.
If Richard is innocent, I think he is.
Blouse from this morning. Mr.
Where's the real killer?
Matters we need to
Exactly.
Before
exactly.
You rest in the presence of our jury. Yes. Yes, sir.
All right, so I'm going to mute out here because I want to listen to these little arguments here that's going on. Tammy's a little bit late. I don't even know how long Tammy's going to take. How long before he would be able to appeal if he's found guilty? And the appeal is straight away. The appeal straight away. You can't watch Delphi. No one can watch Delphi. No one can watch it. It's not televised.
Yes.
All right, I'm going to mute out here while I can listen over to Boone. Hopefully, these guys are back pretty quickly. How long are they going to take with this break? What on earth is going on? Oh, wrong one. Can we have lives while we wait for more court cases? Because we all will miss each other. Oh, I do loads of lives anyway. I don't do them every day, and I certainly don't do them for like 9 hours, but I do a lot of lives. And while the Delphi trial's on, I'm going to probably do more lives to talk through Delphi. But obviously there's going to be other cases that I'm going to pick up on and catch up on and stuff. So I don't know what's going on here. Why are we in recess? What are we doing? Can't wait for Kohlberger's trial. Oof. Oof. That's going to be a long one. That is going to be a long one. All right, going back to Boone. Can't hear a thing, though, when the attorneys are at the table. Oh, she's back.
Amanda and a stack of jury charges are what I need.
Right.
Okay.
I think we're discuss maybe going through quickly one by one. I think we're going to just give them a heads up on some of the ones that are.
And we need Ms. Simon. For you, the charges as they are put together now, pages 1 through 22. And let's just go in order. Page 2, we have the charge regarding the indictment issued and plea of not guilty, presumption of innocence, burden of proof, reasonable doubt. All of that is pretty standard. Is there anything with any of those? Okay, all right. Grave suspicion.
Does the court want objections or concerns as we go through, or do you want us to hold them to the end?
No, let's go, take the objections as we go.
I would object to grave suspicion. As the court knows, the pattern charges, I don't even know why it's still in there, because the pattern charge says, hey, this is totally unnecessary in light of how detailed and comprehensive presumption of innocence and burden of proof are. And that's supported by a number of cases, but as recent as a 2022 case from the Georgia Supreme Court. At their core, jury instructions are supposed to clarify and illuminate. And I think when that charge immediately follows presumption and burden, I just think it's totally confusing. I hate it. I have a visceral hatred for the grave suspicion charge. We would ask the court not to give it. One thing that's nice about these cases is they make it pretty clear that it apparently can never be an abuse of discretion not to. That's our position.
So, Mr. Dean, I ran through the first charges, came to grave suspicion and stopped, because I imagine that you would have a problem with that one. Mr. Hilliard? Mr. Purse?
I think grave suspicion is at the core of this case.
I guess
And I don't think, excuse me for interrupting, I don't think it's error for you to give that charge, since it isn't pattern instructions.
I don't believe it's error. I'm going to take a look at that again, but my thought is to leave it out. But okay, put a little star by that. Jury judges the facts, evidence, direct and circumstantial evidence, credibility of witnesses, expert witness. Okay, witness attacked, page 6. Is there any issue with this charge?
We were talking about this, Judge, prior to it. I don't have a problem withdrawing it. I think we requested it. And I think it just would honestly create more confusion than it would solve. So my last trial, we had an issue with it, trying to tailor it, and we got it tailored, and I won. But I think in this particular case, it's one of those unnecessary charges.
Mr. Dean, I'm going to mark it withdrawn.
Yeah, for what it's worth, I agree, Your Honor. And I also agree I would make the same case as to witness supported. I just don't think we had that kind of thing going on with any of these witnesses.
I would agree with you, Judge. If the attack is coming out, the support doesn't come out too. So.
Okay, so witness supported is withdrawn, as well as witness attacked. Witness impeached.
I think that stays in.
Agreed.
Prior statements.
I mean, I would like it taken out, but I mean, if you ask me to enumerate a reason for it, I can't, other than my visceral hatred.
Yes, okay. So a lot of visceral hate going on here today. Okay, so prior statements remains immunity or leniency granted. We did have immunity granted.
We did, but he asked like 3 questions and answered 3 questions, and it never came up. So I don't have an issue withdrawing it, Judge. I don't see how it's a factor.
Withdrawn. Single witness corroboration, defendant's choice not to testify, statements of defendant. Okay. There was some tailoring, I think. Circumstances of the statements of the defendant, voluntariness defined. Those would remain. Circumstances of the statements, etc. Any issue there?
Not from the defense, Judge.
Okay. Burden of proof as to voluntariness. Okay. Statement of defendant made on November 21, 2022.
And just for the record, just for the record, to make the distinction, because some people later on may not see the distinction. My understanding was all of the previous statements were voluntarily made.
Right.
The November 21st statement was a custodial statement, which is why the Jackson memos and other voluntary questions have to be proved.
Right.
So,
Thank you,
But
Mr.
I mean, just for clarification, with the parties like for on page 8, for it to say something like statements of defendant prior to November 21st, 2022. I mean, I just think
Yeah.
maybe some clarification or some other language in here just to clarify for the jury that everything with voluntariness is included in addition to the additional stuff that comes after the statement for November 21st, 2022. With like the constitutional custodial issues.
To me, I think page 8 looks good,
Okay.
because the jury does have to find voluntariness for all the statements.
Right.
I think the only suggestion I would make is on page 9, when you get to statement of defendant made on November 21. I think the bit on lines 4 and 5 where it says if the statement was given in custody, I think the if part is weird there to me when we're both agreeing that it was given in custody, makes it a little confusing.
So
I think
your suggestion is to take that, that in the,
take that
out, if the statement was given in custody, just take it out.
Just take that out and say maybe the give me one moment, please. Sorry.
You must determine whether the defendant's statement was voluntary and whether the defendant was properly advised of her constitutional rights.
Yes.
I mean, because that's what the pattern,
Yes.
suggested pattern charges say is that voluntary and then the constitutional rights.
Right. This is exactly what I was suggesting. This is like exactly what I contemplated in the requested instructions.
So I'll just remove that if the statement was given in custody, since this is specifically directed towards the November 21st
Right.
statement.
I don't have an issue with the custodial statement then.
Okay,
So we all agree with that.
all right. Moving on to constitutional rights. Any issue there?
I mean, the if part at the outset is that's sort of like the same deal as the last part. You know, maybe it should say because the allegedly, you know, because the alleged November 21, 2022 statement was made while in custody as a result of police questioning. So
Simpler, how about if the statement was made while in custody?
Ms. Parker, if you'll just bend that
That's even better.
microphone.
To simplify that, how about if the statement was made while in custody? Since we're not really asking them to find whether it was or not.
The only, yeah, I'm not asking them to, but yeah, this is only as it relates to the November 21st statement. Correct?
That's the only one.
Yeah, if it's just for that statement, that's fine.
Moving to page 10, defendant initiating further conversation. Okay.
I don't think that this instruction should be given.
Yeah.
Because nothing was introduced in evidence about any such invocation. I mean, some of those earlier interviews did end with invocations of the various rights, or you know, court found that they were legally ineffectual prior to trial and all that. Those were all redacted at the request of the defense, which I had no problem with doing. But because none of it came up, I think the instruction is just inapplicable to this case at this point.
I tend to agree, given the redactions in the pretrial rulings, Judge, we didn't really get into any of that.
Okay. So defendant initiating further conversation, that charge is withdrawn or removed. Burden of proof as to rights. Okay. Conditions Proceeding to consideration of statement. Okay, prior difficulties.
On the conditions precedent to consideration of statement,
Mhm.
there's that bit in there about the rights warning being a condition precedent. As we've been talking about, that only applies to the November 21st interview. So I don't know, I can't think off the top of my head exactly how to tailor that, but maybe it says something like, if you find, as mentioned above, that the defendant's statements were voluntary, comma, and that all of the warnings as to the defendant's rights were given as to the November 21st interview, or November 21st statements.
I think there has to be some way.
There's got to be some way to. Okay, yeah, okay, that's good.
Okay,
That
what's
all
that?
the warnings as to the defendant's constitutional rights were given if required. Because I think it'll be pretty clear at this point when it's required.
Are you okay with that, Mr. Hilliard?
I am, Judge. I mean, we're speaking of the November 21st statement, and I think we all agree, but as long as we find some way to tailor them, because we don't want to confuse them. So
That is the most important thing.
And then that same point would apply to the top of page 11. If you fail to find that the defendant was properly informed of her rights, where required.
Okay. All right. We'll make those changes. Moving down to the next charge, prior difficulties between parties.
No issue with that, Your Honor.
Okay, Mr. Hilliard?
I would object to that, Judge. If I'm going to, I mean, it wasn't really a prior difficulty. It comes back to whether or not, I mean, I just don't see it as a prior difficulty. Prior difficulty is usually between some sort of incident between the two subjects. I just don't, that charge isn't made for that. So I would object to that being included.
I think that the difficulty here goes back to what we talked about earlier. There were witnesses that testified about what they observed as the interactions between the defendant and Quinton. And this is take some tailoring. Mr. Dean?
I think that charge has to be in here. I think definitely, I mean, typically it comes up more in like adult domestic violence cases, but it comes up in child abuse cases all the time. I think definitionally, the incidents that Talia Lacarda and some other people related, they just are prior difficulties under the law. And I think I worry about error if this charge is not included.
I'm going to include the charge. Okay, identification, burden of proof. I don't think there is an issue with this one. DNA. Any issue with that one?
No.
No issue,
Okay.
Your Honor.
All right, definition of crime, intent, no presumption of criminal intent, presumptions and inferences. Okay, we are party to a crime here.
There is, I'm sorry I hate to bring it up at the risk of sounding pedantic, but on 13, there's a typographical error in the bolded language presumption.
I'll change it.
Inferences. Okay.
Not interferences.
The old spell check got you there.
And I read it as inferences, even though I looked at it. Yeah.
And there are some references when they reference the defendant, there's a he and a
his.
Yes.
Yes.
I will, make sure that the pronouns are correct.
Thank you. I'm sorry.
She said it doesn't really matter whether it says his or her, you know, the general stuff.
Okay, anything else up to, okay, we're now on parties to crime.
Yeah, I had a question on this one, because,
I think Mr. Hilliard is yours.
no, this was requested by the state.
Okay,
Yeah, I don't think there's evidence of that.
no.
I don't think there's evidence of number one, number two, that I don't think it's relevant to.
Let me hear from the state.
I'd like for it to stay in.
Party to crime,
Yes.
why?
I don't think I've ever had a case where it wasn't given, and it allows for people, who think, you know, perhaps somebody else was involved in some capacity. What does that mean for us with this defendant? I like it.
Okay, let me take a look at that. Go ahead, Mr. D.
No one else is charged. The state's entire theory has been that my client did this alone. And so it's just completely improper at this point. There's no fact, there's no evidence, there's no theory in the case that points to a party to a crime. So we object to it.
All right.
To me, it's just a fundamental instruction that's given in every case that addresses what does it mean, what is required to be criminally liable for something in the state of Georgia.
Okay.
I don't know that it's one of those instructions that has to be explicitly raised by anything somebody said or argued.
I'll take it under advisement.
Thank you, Your Honor.
Thank you. Guilt by mere presence. Mr. Hilliard. Mr. Dean, any problem here?
I'll wait to hear from Mr. Hilliard.
Oh, I don't have any objection to it.
Okay,
Neither do I.
all right. Guilt by mere association.
Same, I don't have any objection to
Okay. Venue.
it. I think that's the pattern charge.
It is a pattern charge. Malice, murder. Malice, motive. Okay, felony murder. That's one that we want to make sure, I want to make sure is correct. Felony murder, causation in felony murder. Actually, that's essentially the pattern. The felony murder.
These are from the newest
Right.
charges. Okay.
Okay,
Thank you.
that wasn't it. The aggravated assault with an offensive weapon. So let me go back. Felony murder, once I read it, I had a circle for some reason. It's pattern, causation, and felony murder. Any issues with that?
Felony
Okay.
murder, no objection.
Concealing death, simple assault generally.
I think the simple assault has to be given.
Yeah, it's by way of explanation. The aggravated assault with an offensive weapon.
The only suggestion I might make as to that charge is I think we've got it indicted as object that actually did cause and not was likely to cause. And if that is the case, then I might ask that likely to cause language come out of the last line.
Okay.
I mean, that's not like necessary that it be taken out because that is the definition, but to further tailor it. Am I right about the indictment?
The
You are.
indictment,
It is charged as did result in serious bodily injury.
yes.
So you would like for it to say, that it actually does cause and just remove the other.
Yes.
Mr. Hilliard,
He wants it to say actually does cause versus likely cause.
And if it's a weapon, is any object that does cause, right?
Or just say causes, I guess,
Causes.
since we're taking that out.
Causes or actually does cause.
And not just object that causes,
Why don't we do that?
object that causes. I think that's good.
All right,
I don't have any great objections.
okay.
I mean, I think it's at the risk of being pedantic, I don't want to object to the language.
All right, determining if weapon is offensive. That charge,
And this one's pulled straight from the pattern.
okay. Cruelty to children in the first degree, that's also statute. Any issue with cruelty to children in the first degree? Okay. Voluntary intoxication, not a defense.
May I, cruelty to children in the first degree, may I ask that item 2, cruel and excessive, read as cruel or excessive? I know it's charged in the conjunctive as cruel and excessive, because that's how we have to charge, but in terms of what we actually have to prove, it's not necessarily both, it's one or the other. So I would ask that be an or.
Thank you, Mr. Hilliard.
I would leave the language the way it is in the indictment. I think it's indicted as cruel and excessive. I don't have an intent here, but
It is indicted that way, but if we don't change that to or, and I have to ask for a totally separate instruction that the whole and means or instruction, then I'd rather not do that. Because I think that's like the only place in this indictment where we've got a conjunctive that we might want them to read as disjunctive, and I don't think that I'd rather not ask for the whole separate instruction that, hey, there are spots where, certain crimes can be committed in more than one way, and the state need only prove one, even if they've alleged more than one, and that whole deal. I'd rather just change this and to or and be done with it.
The case law forces us to charge with an and rather than an or, but the case law also says that if we only prove one, the other is surplusage. And the simplest way not to have to explain that to the jury is just to make it an or.
Mr. Hilliard, anything further?
I just think if you don't stick to what the language in the indictment is, it's going to create an issue back there in the jury room. That's my humble opinion, Judge.
All right. My inclination at this point is to have number 2 read cruel or excessive, but I'll take another look at it. But that's my inclination. Moving on then to voluntary intoxication, not a defense.
I don't think I requested that. So, I mean, I would object to it because I don't think anyone's raised that as a defense. But it's mine, I withdraw it. But
I believe that may have been yours. Mr. Dean?
I requested it because no jury instruction has ever been raised by the evidence more prominently than that instruction has been raised in this case. It's an accurate statement of the law, and the jury absolutely must hear that principle of law in this case.
I'm going to include it. False report, we'll make the changes there. He, she, we'll make those pedantic changes. All right.
It does say, it says misdemeanor in there,
Oh, I see it.
and I don't think the jury's to know the distinction with respect to punishment.
Okay.
I'd suggest making that false report of a crime is when a person blah, 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 and then take off the guilty of a misdemeanor part.
That makes
Yeah.
sense.
Yep. Okay, so that charge goes in without the last phrase is guilty of a misdemeanor. That comes out. Okay, making a false statement. Okay. Verdict generally, unanimous verdict form. Court has no interest in case. Sympathy, responsibility for sentencing. Deliberations, jury use of technology, retired to jury room. So going back through, page 3, grave suspicion, Mr. Hilliard would like that to remain. And I'm inclined to allow it to remain, maybe because there's not error. Although I agree with you, it's not necessary. Witness attacked on page 6, as well as witness supported on page 6, have been withdrawn. Page 7, immunity or leniency granted witness, that will not be given. Page 8, statements of defendant, that on page 8, really page 9, will be adjusted to reflect the difference between November 21st statement being in custody and the other statements were not in custody. Constitutional rights. We made a change there, did we not?
We did. If the statement was made while in custody, we think that you find that out.
Right. Defendant initiating further conversations, that will not be given. Conditions proceeding to consideration of statement will reflect only as to the November 21st, 2024 statement. Prior difficulties will be given over objection. Page 13, inferences will be corrected in terms of the spelling. Page 14, parties to a crime or parties to crime. The state very much wants that there. The defense does not want that there. Want it given. I'm going to take a look at that.
Allow me to revise my position. I don't very much want it there. I just,
Okay. Thank you, Mr. Dean. So, parties to crime will not be given. And then aggravated assault with an offensive weapon.
Which page are you on?
I'm sorry, page 18. Will be, the last line, I believe, is changed to an offensive weapon is any object that causes death or serious bodily injury if used against someone. Also on page 18, cruelty to children in the first degree. The number 2 enumeration is going to be cruel or excessive. Otherwise, it remains the same. Voluntary intoxication will be given over objection. False report of a crime, also on page 19, will be given except the last part of that charge is guilty of a misdemeanor will be eliminated. And everything else, I believe, is pattern.
Can I ask a sort of a mechanical question?
Yeah.
When these charges are actually given to the jury, and assuming we have objections to make, I mean, according to statute, you know, we both get an opportunity to state on the record if we have any objection. Is the written charge that you actually give going to be part of the trial record?
Yes.
Okay.
And I plan for the written charge to go out with the jury.
The only reason I ask is I assumed it would be part of the record, but I wanted to be sure, because if it comes up on appeal, you know, I think you got to have the charge that was actually given, where you can reference, here's where it looks at. Well, here's where you can find it to see what we're talking about.
Okay. Anything else regarding the jury instructions?
Only one thing that I just noticed, Your Honor, and I could be misreading this, but on the bottom of page 19, making a false statement, I've tried to like diagram this sentence, and it appears to me it may not be a complete sentence, and I think it's probably because it was crafted from the statute, but I think it needs to say at the end something like commits the offense of making a false statement, or in the alternative, at the front end, it should say a person commits the offense of making a false statement when she knowingly and willfully
That last construction makes sense to me.
Yes.
Yeah, that's
It's
fine.
more clear.
Okay, thank you for that. Note. Is there anything else that you're finding here in the jury instructions? And of course, you know, take a look at it. If anything else comes up, we can make change. We can discuss it and make changes as needed. But we're gonna have the jury charges. We believe it's gonna go out ready to go. And email you a copy for your review.
Can we get a copy tonight, maybe, Judge? And just, if we have any issues, just show up at 9:30 in the morning and deal with it then, if that's okay?
Did you just change the time?
No. I'll show up at 9:30. The jury's still back at 10.
No,
So.
no, we'll do 9 o'clock just in case.
Okay. I don't care either way.
I like 9:32, but we're gonna do 9 o'clock.
I got to drop my wife at the airport, so I'm going to be here at 6. So it doesn't really matter to me. But I think if we have it tonight.
Yeah, you'll have it tonight, and if there's anything else that we need to attend to, we can. Okay.
Works for me.
Okay, is there anything else tonight? Okay, we're in recess until 9 o'clock tomorrow.
Thank you, Judge.
Thank you, Judge. Everybody have a good night.
9 o'clock tomorrow. 9 o'clock tomorrow. Court TV were very quick to end their live stream then. They all wanted to go home. Yeah, well, I'm ready to sign off, but look, I just have to say this. The utter BS that's going on in Delphi is just absolutely insane. I just got a little bit distracted by Twitter and I dared to look at Delphi, and the phone expert's been on. It's Chris Cecil, who's the guy who spoke at the 3-day hearing in July, August. And he says that the phone died, Libby's phone died for 6 hours, then it spiked back on at 4:30 a.m. And that's why 15 text messages came through. It spiked back on. There's no such thing as spiking back on. When your battery is dead, it's dead. When your power's gone, there's no power at all to spike anything. All right, there's loads more, but I'm just brain fried. So I'm going to sign off and go and listen to somebody else for a change. I'm going to go and listen to whoever has been in court, whoever's live right now who has been in court. That's who I'm going to go and listen to, because this is just absolute BS. Anyway, so in Leilani, that was the charging conference. That is to decide agreed between the parties what instructions the jury are going to get regarding Leilani's charging, what they are actually charging her with. So all that's been decided. So the defense rested. They decided not to put on any witnesses. So that was their choice. Leilani chose not to testify. That was her choice. So therefore, there is no rebuttal argument required by the state. So in the morning at 9 a.m., they're going to come back. They'll do closing arguments, jury instructions, and then the jury will get the case. So we could have a verdict by tomorrow night. We could have a verdict here. We could have a verdict. So exciting. So she said 9 a.m. tomorrow. So I'll go live as soon as the court stream goes live. All right. So yeah. Thanks everyone. Thanks mods as always. And I'll see you tomorrow. Same time, same place. Bye guys.